You want to mention? Yes.
Well, it's writ appeal, my lord. Filed the last month, my lord. The pensionary benefits has been withheld by Authority Canara Bank, my lord.
Pardon?
Against order of that single judge, my lord, this writ appeal is filed, my lord. Kindly have this matter tomorrow, my lord.
What is that urgency?
My lord, the pensionary benefits has been withheld, my lord. He is already a retired person.
Pensionary benefit.
Please, my lord.
27th is working?
Please.
27.
Shops in our occupation belonging to the municipality have been sought to be sold in public auction on 26th Thursday. Now, we have got the right of first option, first refusal, but those shops have been reserved for persons belonging to scheduled caste and scheduled tribes. Consequently, we are neither in a position to participate in the proceedings nor take the shops on lease. Kindly have it tomorrow.
Day after?
Thursday will be the auction.
The day after is?
Right.
All matters which are, since it is the last week. Since this is the last week, normally we will not grant the permission unless it is urgent and something is made out. Cause is made out. All matters which are permitted may be listed in separate book.
Serial number 31 and 64, we permit them to withdraw.
But withdraw 31 and 34. What is that contempt?
They've already affected Tata in favor of the.
31-259 of 24, learned advocate Mr. Shivraju MK files memo of withdrawal dated 23/9/24 state which reads as under report the memo. In view of the above memo, dismissed as withdrawn.
Lordships,
kindly. Number 4, my lord.
Lords, in 64, Lords, in 64, Tashidar's presence was ordered, my lords, that may also be dispensed.
Same order. The presence of in view of the dismissal of the
Let's
in view of the dismissal cum withdrawal of the contempt petition, the presence of presence of Tehsildar directed above, directed earlier stands dispensed with.
Please.
Let's kindly. Let's, it's a contempt petition, let's.
The presence of, right on the presence of Tehsildar in this matter is noted, which was directed in the earlier order. However, since the contempt petition is withdrawn, the presence will not be required and the same is cancelled.
Serial number 9, it's complaint. Kindly it may be drop the complaint. It's serial number 9.
Serial number 9.
Serial number 9.
What about 64?
64 only you. 64 was the.
This is in 64. Tehsildar one. Okay.
Lordships, kindly.
So which matter you are withdrawing? You are withdrawing?
Serial number 9.
9.
Serial number 9, it's complaint.
561 of 24. Learned advocate Mr. Bukhanappa SB stated that the order under contempt is complied with. Accordingly, nothing survives in the petition. It is disposed of as not surviving.
Serial number 37, my lord. 62.
Serial number
Serial number 37, my lord.
37. Yes.
File objection to the application filed for impleading.
Here for the proposed respondent number 3, madam.
2 weeks accommodation may be given.
Yes. Ma'am. Have any objection?
Oh, my
They have filed the application, I will have.
At the request of learned advocate Mr. Krishnan Sevi for the appellant, stand over to 25th of October.
This is contempt petition, Lord, and petition service have been withdrawn.
In line. Yes.
Let me make one mention.
Yes.
Cement factory has been closed down because of non-issuance of permits.
What is
I had
closed?
moved it, my lords, it's a
What is closed down?
cement factory, my lords, which is with the mining, in the mining area, cement factory, my lords, which about 10,000 people's livelihood is at stake. I had moved it about 10 days back. Your lordships had given the date as 24. Unfortunately, it got listed on Saturday and got adjourned to 21st October. You're filing an early hearing application. In fact, I had mentioned it.
Your junior mentioned.
Yes, I was not in the country. That's why your lordships had given it as 24. But now, my lords, it's gone to 21/10. Lords, the urgency is 10,000 people is at stake and the entire factory will be shut down. It's a big unit, my lords, in the country's leadings.
Can you file the IA tomorrow?
IA is being filed in the counter tomorrow or day after.
List IA tomorrow.
Please,
Then we'll consider.
please.
Let's.
Tomorrow all matters in separate board, including IA and student. Make it a common board along with the student matter. Student matters के साथ जो भी mention हुई, so that we can take it in. Hold it. Yes.
Yes,
My
contempt
lords.
petition, my lords.
Pardon?
The petition service have been withdrawn, my lord,
Withdrawn.
and there are no salary since 1 year, my lord. And they are all group three employees. And
Pardon?
this is a contempt petition, my lord.
Contempt petition, what is the urgency?
Lord, because they are without surveys and no salaries also being paid.
30th, next Monday.
But it's serial number,
My lord, serial.
serial number 91, my lord. There are two office objections here, which we are ready to comply. One is, we are not served the copy, we have already served the copy. And the index, they raise the objection index, it might be overruled. They have raised two objections, my lord. One is they have served the copies, which we have filed in the counter, my lord. And another thing is they have raised objection in the index column. That might be overruled.
Index has to be filed. There is instruction from the Chief Justice.
So we
That
are
without index as filed in the original petition has to be filed along with the writ appeal.
no, that.
So unless you are complying with, I am going to tell the Registrar Judicial that don't circulate such matters. Because for me, it is very difficult to find out the page without index, as was found in the original petition. Your practice here, I am not following, as far as the index is concerned.
Fine.
No,
My lord.
do it,
Will comply.
you comply.
My lord,
Within
serial number-
time is granted for 2 weeks to comply with objection.
The tender matter.
Whatever, 2 weeks, thereafter the petition may be posted.
Serial number 23, my lord.
Yes, madam.
Serial number 23, my lords, the
20.
arguing counsel has some inconvenience today.
What
Matter
do
may
you-
be adjourned, my
What
lords.
do you want?
My lords, the matter may be adjourned. The arguing counsel has some inconvenience today.
Will be adjourned to 28th of October at the request of
23
learned
also, my lord.
advocate.
Grateful, my lords.
One
Your Sanjati Sajan Purviya.
Please, my lords. for
23
off.
one
The
also, my lord.
appellant stand over to 28th of October, as requested.
Connected matter, 23 one also.
Pardon?
Connected matter, 23 one.
It will also go.
Serial number 21, my lords. Praise for 2 weeks accommodation, my lords.
It will go 29th of October. Same order.
Serial-
at the
my lord,
request of
serial
learned
number
advocate,
54.
The appel writ petitioner, as requested, stand over to 29th October.
Serial number 24,
Number
my lord.
54, my lords.
Serial number 24, my lord.
Yes, Mr.
Lord,
2 weeks time maybe.
Serial number
Serial number
20.
40, contempt matter, my lord.
43.
Yes, my lord. There, my lord, there is a further communication given to the second respondent for complaints of the order. They are at it, my lord, therefore, we urgent to. I'll pass on this letter to.
At the request of learned advocate for the complainant, 43, stand over to 29th of October.
My lord, serial number 54, my lords. I am for the petitioner. I seek for short adjournment, my lords.
What do you want?
Short adjournment, my lords. My
Adjourn.
seniors.
30th October, as requested by learned advocate for the petition.
Serial number 24, my lord.
24, yes.
2 weeks adjournment.
Pardon, 2 weeks.
2 weeks.
Why?
I'll engage senior counsel. Some inconvenience.
All that. 21st of October.
Serial number 57, my lords.
Pardon,
Serial number
yes,
57, my lords.
57.
2 weeks time may be granted. I am for respondent, my lords, connected with the contempt petition, my lords. I am not feeling well. I will physically appear, my lords.
So what do you want? Time?
Time, 2 weeks time may be granted, my lords.
30th October. As
Much obliged.
requested by learned advocate for the appellant. You are a government advocate?
No, my lords, I am respondent in the writ appeal and contempt, complainant in the contempt petition, my lords.
No, then you wait. Why you are not feeling well, all right. As requested by learned advocate, the respondent, Mr. Adavishaya B. On the ground that she has indisposed health. Yes. and-
Much obliged.
First.
Case number 2, serial number 1. The Chandrakant Thakur.
For the state.
No, these are the matters for final hearing.
My lord, this actually.
All the entire board is same.
This has to be heard, madam.
This can go.
May I make one submission? Your lordships are pleased to grant an interim order for admission. The question is only one of fees, my lords. Now in the third year, again, the question is payment, we could not, since some payments could not be made because they are demanding more amount. Your lordships have permitted us to continue the classes. Because of the non-payment, again, my lord, there is some harassment by some of the institutions, my lords. May we pray, my lords, now the payment that has been made in the first year, my lords, same payment, your lords may kindly order us.
On next day will.
My lords, may I submit on behalf of petitioners in 4 and 5, my lord, serial number. My lords have, on the last occasion has passed an order that they can be permitted to attend the classes. Now, my lords, the examination is in November, second year. They have not even taken admission. Without admission procedure, my lords, they cannot attend the, appear for the examination. Therefore, my lords, they may be directed, the colleges which they have now been ordered to be taken, they may be permitted to get admission there and complete the process of examination pending disposal of this petition, my lords.
So either you file IA or will be effectively taken up for a, we can modify it. Not in this fashion.
In fact, my lords had passed a detailed order on the previous occasion, my lords, that the question is only one of fees, my lords, and my lords had permitted them to attend the classes, my
We
lords.
know that.
Please, my lords. Now, the only question is, my lords, now the examinations fast approaching, my lords, if they are not permitted to appear for the examination, that your lords may, please.
Examination by the university, my lord, in November.
In November.
November.
Then let it go to on reopening, 4th of November.
My lords.
Would be any day in the October last, my lords.
Can come by filing IA, Mr. Counsel. What is the question? In such fashion, we are not modifying or adding to any interim order. On mere askance or on mere mention.
May I make a request, my lord? There is one another connected writ petition, my lord, 15,703 of 24. I only want that petition to be listed along.
Which one?
15,703 of 24. It is not listed today. I'm making a request.
Is listed on which date?
It is not listed, but it's a new case, fresh case.
Fresh case. I'll memo tomorrow
Well,
and tell that it is to be listed.
well,
along.
should do that.
Yes, any further mention?
6 and 7, sir. 8 items.
Number 7. Abhishek Mali Patil.
But 7 may be called, my lord, day after tomorrow. Because this seat has been given, only thing is, my lord, they have not submitted the relevant document. They are waiting for the documents.
Still number 8, I think. 7 is for withdrawal. One of them is for withdrawal.
7 withdraw.
6.
6 you want to withdraw?
Yes, serial number 6 is for withdrawal, man.
6 is day after tomorrow.
Yes.
No. 7 day after tomorrow is.
7 day after.
Yes.
This is day after.
This is serial number 6, man.
We are withdrawing.
Yes, man.
Memo dated 3/9/24 figures on record of the petition, which reads as under quote the entire memo. In view of the above, in view of what is stated in the memo, the petition is further to withdrawn because disposed of accordingly.
Tomorrow, no? If I.
This list number 1, serial number 1.
In list number 2, serial number 8, my lord, it goes with serial number 1. My lord. Serial number 8, my lord, in the second list, it goes with serial number 1.
Right, to be listed with.
Well, in serial number 1, my lord, I appear for the respondent number 2. Mr. Arun Kumar had made some submissions here on the last day. Whenever lordship permits me, I like to add a few more words. Whenever the court permits.
Which one? Serial
I'm
number?
this one, this jute, the sugar and jute, sugar versus jute case. So I am for the respondent number 2, the Jute Mills Association. Mr. Arun Kumar, he had made some submissions on the previous day. The lordship so permit, I'd like to add a few words whenever lordships so allow me.
Can add after the.
After Mr. Holla.
Few, but few, only few. Only thing that we can write judgment provided you complete the matter. Yes. You want the judgment immediately and you are preventing also too.
Sorry, my lord, my apologies, my lord.
Not to you. Nothing to be sorry about.
General observation.
Yes, yes.
My lord, if I can request your lordship, my lord, what must, volume 1 ಕೊಡ್ತೀರಾ ಅವರಿಗೆ? Volume 1 of the writ petition, one of that objections that we had filed. Writ petition ಅಂತ ಬರುತ್ತೆ ನೋಡಿ. Page 124.
So is another writ petition.
My lord, my lord, what happened? Same writ petition. What they did was, my lord, when they filed, my lord, the writ appeal, they didn't produce, my lord, all this.
No, this is by Union of India, 1405.
Correct.
Which Mr. Kamath argued.
Yes, ma'am.
And this is same
Arising out of the same.
You are showing writ petition.
Because these were not produced before your lordship, my lord.
Correct.
Please come to, my lord, page 124, my lord.
Yes.
My lord, this is a report on the Committee of Regulation of Sugar Sector in India. If my lords may turn to, my lord, page 126. Central Government of India, my lord, constituted a committee. My lords may look at page 126. The Government of India constituted this committee to comprehensively look into all issues related to the regulation of the sugar sector and suggest ways and means to change those regulations in a manner that better promotes efficiency investment and sets this sector on a higher growth trajectory, increasing the employment in the rural areas, enhancing the income of all those involved in the sector. Because, my lord, farmers, sugarcane is grown, my lord, crores of farmers are there. Now, my lord, please come to, my lord, this committee report, 132, my lord, if your lords come to 132. Paragraph 11, my lord, at page 132. Jute packaging material compulsorily used in Packaging Commodities Act of 1987 mandates that sugar be packed only in jute bags. It is estimated the sugar industry that this leads to an increase in the cost by about 40 paise per kg of sugar, besides adversely impacting the quality on account of ingress of jute fibers of jute bags. Further, there is often a shortage of jute bags. Sugar industry like cement and fertilizer industry earlier should be removed. Cement and fertilizer were removed from the compulsory use of jute bag. From the purview of that act, if the use of jute is uneconomical, such a mandatory use of regime is unlikely to render the jute industry profitable. All it ends up doing is impose a loss of efficiency in consequence of this distortion of choice. Please come to, my lord, in furtherance of this was, my lord, way back in the year 2012, my lord, this report. Give me the other one. Page 1176. 1176. Which volume is it? My lord, now, in the year 2024-25, Commission for Agricultural Costs and Prices, my lords may turn to, my lord, 1170, not report master. 1178 volume ಕೊಡ್ತೀರಾ ಅದರಲ್ಲಿ ಇದೆ compilation ಅಲ್ಲಿ. ಅಲ್ಲಿ ಇದೆ. Page 1178, 1178, volume 3. My lord, this is the price policy.
Now, the demand of sugar and the importance of sugar in economy has nothing to do with this. What is the relationship?
My lord, what has happened is the jute bag results, my lord, if we have to use the jute bag, my lord, it will for every kg, my lord, 40 paise increase, my lord, there will be there in the sugar.
45%?
Paise per, my lord, this thing. That's what, my lord, the order, my lord, also says.
Wastage.
Yes, my lord.
Wastage.
Increase in the cost.
Increase in the cost.
Cost of sugar.
Because of use of jute bag.
Yes, my lord. Because per kg, my lord, what happens is, my lord, jute bag is costlier. HTP bags, my lord, are cheaper. The difference is, my lord, huge. And 60 rupees, my lord, difference is nearly 60 rupees per bag. Resultant position is 40 paise a kg, my lord, sugar prices increase. That's what, my lord, this says. But more important is, my lords may come to, my lord, this volume 3, page Agriculture Commission for Agricultural Costs and Prices itself. Sorry.
Write down, learned senior advocate for the original petitioner, Mr. Uday Valla for the original petitioner, invited attention of the, so that I may not forget your submission.
Yes, ma'am.
Invited attention to report of the Committee on the Regulation of Sugar Sector in India, the way forward, which was produced at Annexure C in the main petition to highlight the importance of the sugar industry in the national economy. To further submit that not only the sugar demand has increased, which is to be met by surplus energy produced by the industry, the use of jute bags, according to him, has the effect of increasing the total cost of the sugar.
And, my lord, one more. Cement and fertilizer has already been removed. My lords may please to see, my lord, in that.
Submitted that the commodity of cement and fertilizer have been
Removed from the use of the compulsory use of jute bag. Reason is simple, my lord.
excluded
Moisture.
from the compulsory use of the jute packing. Then what is that? That paragraph 11?
Yes, ma'am. 11
Then
subpara
what you have
2.
submitted?
Then, my lord, please come to 1178. Commission for Agricultural Costs and Prices itself, my lord, in the year 2024-25. 1178, my lord.
1178, yes.
Please come to, my lord, 1189, the recommendation.
Yes.
Paragraph, my lord. 8, my lord. My lords get that, my lord. 1190, paragraph 8. Review of the JPM Act. JPM Act has created and eschewed demand of jute sacking, but it has also acted as a barrier for technological advancement and product diversification. Commission reiterates its earlier recommendation to review the JPM Act of 1987 to reduce the mandatory packaging requirements in a phased manner so as to ensure adequate supply of raw jute for other diversified jute goods. Then, my lord.
What is this JM?
JM, my lord, that is that act, my lord. Jute Packaging Act.
Jute Packaging Material.
Packaging Act, my lord.
Packaging Material Act.
Material Act, oh, I see.
Then, my lord, please come to, my lord, 1197.
It was submitted that the Jute Packing Material Act has created assured demand for jute sacking. However, it has also acted as a barrier to technological advancement and product diversification. This was sought to be submitted on the page of the price policy jute report by the Commission of Agricultural Cost and Prices. Department of Agriculture and Farmers Welfare, Government of India. Next, what is?
1190, my lord, if your lordships come to, sorry, that is what I said, my lord. Please come to my lord 1197, my lord.
1197.
7, my lord.
Yes.
Modernize, my lord, last paragraph.
1197, yes.
Modernization, diversification in jute industry.
Hmm.
Indian jute sector is heavily dependent on the government demand for food grains and sugar packaging. Compulsory packaging of sugar, food grains and jute packaging material was increased from 90 to 100% with effect from 30th of November 2018 under the JPM Act of 1987. Requirement of government for jute sacking bags has increased significantly due to higher production and procurement of food grains. It is evident from chart 1.4 that the share of sacking in total jute production consumption has risen from 73% in the years 2012-13 to 80.4% in the years 2022-23, while the share of Hessian and other jute manufacturing products has declined significantly during the period. Continued high reliance on sacking by jute mills has been a major impediment to diversification, modernization, and technological upgradation for the jute industry. Therefore, to revitalize the jute sector and enhance the income to jute farmers is essential to gradually reduce the compulsory packaging of food grains and sugar and thereby freeing up the capacity for production of value-added diversified products. This, my lord, is reiterated again and again, my lord, in this report. Ultimately, my lord, they say at page that, my lord, it must be, my lord, totally given up. My submission to your lordship says, my lord, this is, my lord, what the Agriculture Ministry itself says.
It was further submitted on the same report that because of modernization and diversification of the jute industry, the total jute consumption has risen from 73% to 80.4% in the recent period. On the basis of these aspects, it was submitted that the notification providing for compulsory packaging of sugar in the jute bags operates adverse to the jute industry, to the interest of the jute industry. Yes.
Then, my lord, the effect of, my lord, what happens is in a jute bag, my lord, when they manufacture, they use what is known as a batching oil, my lord, because jute is hard. So it has to be softened. Batching oil, my lord, is carcinogenic. It causes cancer. Please come to, my lord, page 1350, 1350.
Page?
1350.
1350.
Yes, my lord.
One three five zero.
Yes.
Yes.
1350.
Yes.
Carcinogenic property of JPO. JBO variety of jute batching oil. Please come to, my lord, running page, my lord. The effect, results, please come to page 1355.
Yes.
Experiment 1, gross examination, sorry, 1355. Experiment, my lord, in the middle. Gross examination results, you know, your lords get that. Tumor development was observed on the skin of both PAP alone or JPO alone treated animals belonging to group C and B and C respectively. First tumor was noted after 16 weeks of treatment in group B and after 13 weeks of treatment in group C. No animals belonging to group A, that is acetone treated controls, developed tumors. When batching oil is not used, there is no tumor at all. Rate of mortality, last sentence in that paragraph, was found to be total number of mice developing tumor in group B was 3 out of 8. 3 and 8 out of 9 surviving animals in each group. These are all, my lord.
It was then submitted that the use of jute batching oil in the jute bags has the cancerous effects. This was sought to be highlighted with reference to the research article on carcinogenic property of JBO/P, variety of P into bracket, variety of jute basing oil.
1360 is another, my lord, report. That also, my lord, says the same thing. 1360, my lord, please come to, my lord, page 1362, my lord. 1362.
Another report.
At page 1362.
One three.
62, my lord. Sorry, can I persuade you, lord, to look at
Another
1360, my lord,
investigative
bottom,
report.
discussion, 1360, bottom.
By the supervisor Lund, LU and University, was also relied on.
It develops, my lord, tumors.
ऊपर के paragraph, page 1197, ऊपर के sentence में. After this sentence, page 136. Yes.
Jute bags also, my lord, result in
135
absorption.
135 earlier, and now 1364. Yes.
Jute oils also, my lord, results in absorption of moisture. Please come to, my lord, page 1364. The University of Lund went into this. That's why, my lord, they removed cement and, my lord, fertilizer from use of jute, compulsory use of jute bag.
It absorbs the moisture. All right.
Yes, my lord. Page 1364, my lord, the research paper also we placed.
It also absorbs the jute bags also has the tendency of absorbing the moisture from it was submitted. Yes.
In fact, 1318, if your lordships come to, my lord, all foreign, my lord, entities. In fact, your lordships have seen, on the last occasion, I did mention in passing. 1318, if your lordships come to.
Yes. 1380, yes.
1318.
Yes.
My lord, Coca-Cola, Ayush, my lord, everybody, my lord, these are all, my lord, various emails, my lord, that have been sent. Parley Agro, my lords, get that at page 1321.
1320.
My lord, it starts at 1318. Coca-Cola says don't use jute bag for sugar when you transport. 1318, my lord. My lords may be pleased. Dear Shri Krishna Kant ji, change from PP bags to jute bags poses a serious contamination and food safety risk via handling of jute bags as suppliers, location, transportation, storage, transportation, unloading, so on so at bottling plants. In view of this, we cannot accept any sugar pack in jute bags.
Correct.
We said, my lord, 20% we'll have to do it. They said, no, you can't. Then, my lord, please turn the page over at page, my lord, 1321, Parley Agro. They also say, my lord, that packaging conditions, my lord, bottom, sorry, 1321.
Yes.
Last three lines, my lord, from the bottom, packaging condition, packed in HDPE bags with PP lining. So, my lord, not jute bag. We don't want jute bag. Similar, my lord, are, my lord, the letters written by, my lord, various other in Nestle. My lords, get that at page 1328. Yes, my lord. Nestle. Packing, my lords, get that, my lord. Impervious to moisture, suitable to protect, preserve the contents. This is, my lord, jute bag, my lord, is always, my lord, it absorbs water.
Yes.
In fact, sorry, 1326, my lord, if your lords has come to 1326. Abbott Nutrition, my lord, this is a medicinal company. It also says, when you send sugar, don't pack it in jute bags. I prepared, my lord, one small note, what they've prepared. Just pass it on, my lord, so that. Access to your lordship, my lord. I know it's not that easy, my lord. We put everything on your lordship's shoulders and run away. All these, my lord, I have put, my lord. Please look at it, my lord. Section 4 of the JPM Act, that's the act, my lord. It mandates existing level of usage of jute material, quality of raw jute, all that, my lord. I have made copies. But I'm passing on the act also, my lord. It's a short act. I have it.
It's in my volume.
Anyway.
What is this?
That's an act, my lord. Yes, my lord, because it's a short act. I just placed it, my lord, because your lordships will have to look at it.
But it is there in my compilation as well. It is there in my compilation.
Section 3 and 4, my lord. Gujarat High Court, my lord, had an occasion to deal with this matter. Can I pass on, my lord, one judgment of the Gujarat High Court, where they say, my lord, that every year, my lord, there has to be, my lord, Gujarat High Court. But they have a copy. Just give it. I'll give just one. My lord, please come to last 3 lines on the first page. Detailed report has been given to the jute that batching oil used in jute is harmful to the health of human beings. This is one. More important is, please come to, my lord, paragraph 32. 3(2). Can I persuade your lordships to come down, my lord, in para 32 to, my lord, 14 lines from the bottom, my lord, at the top. Looking to the provisions of, my lords, got that, my lord? I'm sorry. 14 lines from the, my lord, from the top. Looking to the provisions of section 3(1) of the Act, every year is a separate year. Therefore, what is just for last year on the basis of last year's jute policy cannot mechanically be followed for the current year of 2006-07, but need of 100% ought to be evaluated independently of last year's percentage of policy. So, my lord, every year, whole exercise is to be undertaken afresh. In the incident case, my lord, 2023, my lord, they conducted that. Thereafter, my lord, it's not been done. And they, my lord, continue, my lord, with that. Therefore, we are, my lord, assailing that extension.
July 2022.
Last meeting, my lord, was 21st of July 2022. Thereafter, there is no meeting of the SAC, my lord, that is the committee which has to, my lord, go into this aspect. Para 33, my lord, if your lord is turned to. Next page. Where? Last 3 lines, my lord. The Gujarat High Court, my lord, therefore, wherever a legislation is running against the Parent Act, last 3 lines of para 33. Decisions are amenable to judicial review, and in view of these facts, I hereby quash and set aside the notification. What happened was, in that year, my lord, also, my lord, they did not, my lord, for that year, they did not, my lord, have a meeting. They did not, my lord, give any recommendation.
This 33 is quoted from somewhere. 33 paragraph is quoted from some decision.
Dalmia, my lord.
Dalmia.
Correct, my lord.
Yes.
Therefore, my lord, my submission to your lordships is, if your lordships now look at, my lord, the notification, my lord, please take, my lord, I'm sorry, I had to take your lordships through these bulky volumes, my lord, but ultimately, my lord, this very hardly, my lord, 3 pages, 5 pages.
Page.
Please complement the writ appeal itself, my lord. My lords may take notice court
Writ
master.
appeal.
Writ appeal.
Yeah.
The earlier notification, my lords get that at page 120.
No, this is the SSC meeting. One notifications.
One. My lord, 120, the meeting of the SAC.
Yes. Ministry of Textiles. Yes.
My lord, no, my lord, it is a meeting of the standing advisory committee. Page 120, my lord.
Yes.
Minutes of the 30th meeting of the standing advisory committee. I'm sorry, my lord, did your lordships? Writ appeal, my lord? My lord, it's the writ appeal, my lord, not writ petition, my lord.
This is minutes.
Minutes of the 30th
Correct.
meeting of the standing advisory committee.
Yes. So this is what
Please come to my lord, running page 124. Sugar is totally exempted.
what is this? This demand was reduced. See, same.
Please, my lord.
During this period, the demand was less.
Demand, my lord, yes. Please come to my lord, para 6. Last time, my lord, we did mention this. to
No,
your
this
lord.
was read by Mr. Kamath for what purpose?
No, I read it, my lord.
You read it.
Yes, my lord.
I also read it to show that earlier we had exempted, but in the next meeting,
We'll-
the
we'll-
SSC
we'll-
recommended.
Please come to my lord, page 120, para 6. That year, the sacking average production was 9 lakhs. Para 6, my lord, at page 122. Anticipated there will be a requirement of 14.3 lakhs. And it has not, my lord, changed. I'll point out that. When they came up with another meeting, please come to my lord, page 124.
So
Sorry,
you're
122.
Same paragraph 6 you relied on.
Please.
So,
Then
so
para,
demand of the jute bag is more than supply.
correct. Same thing continues, my lord, in 2023. I'll point out, my lord, in the background of this, please come to my lord, 115.
So this goes with you or against you?
It's in my favor, my lord. Because I need not, my lord, there's a shortage of bag. And I'll point out that.
Shortage of.
Yes, my lord. My lord, page 124, recommendation. D, sugar, my lord, be exempted completely. D, my lord. Lord, the next meeting, sorry. This was the 30th meeting.
Lie down. The minutes of the 30th, 30, meeting of the Standing Advisory Committee held on 21st July 2022 were referred to by learned senior advocate for the original petitioner to write the contents of paragraph 6 thereof, in which it is stated that the demand of the jute bags is more than the supply, which was indicative of the fact that there is a shortage of jute bags. Full stop. We also drawn attention of the court to the finding of the advisory committee, which recommended that the sugar may be exempted completely.
Please come to the next, my lord, 31st meeting, page 197.
197.
7.
Same compilation.
Yes.
Yes. 197. Yes.
Please come to my lord, paragraph 5 at page 200.
197.
197, my lord. My lords get that, my lord. Minutes of the 31st meeting. Sorry.
Yes. Now 31st meeting. Eh?
Yes, my lord.
Yes.
That was the 30th meeting. This is the 31st meeting on the next year.
Next, sir.
23rd of May, 2023. That was, my lord. Your lordship saw, my lord, it was in 2022.
Page 196, 31st meeting. Yes.
Please come to, my lord, page 200, paragraph 5.
Para 5, yes.
Yes, madam. The jute commissioner submitted that the average sacking production is around 9 lakhs. Same thing, my lord, which your lordship saw, my lord, in 2022. It is anticipated there will be requirement of 11 lakh metric tons of jute bags.
Para 5
Five.
is jute commissioner submitted that. So where you are reading?
My lord, the jute commissioner submitted that the average sacking production is around 9 lakhs per metric of
That
MT.
you read yesterday also.
Last time I read to your lordship showing that there is no improvement. 9 lakhs, my lord, and the anticipated average requirement is 14 lakhs, 13 lakhs, sorry, of jute bags. Same thing, my lord, there is no change. And yet, now please come to, my lord, page, sorry.
Write down no improvement in the availability of jute bags. Then into bracket page 200. Paragraph 5 of the report of 31st meeting. Yes.
Then, my lord, please come to 202, same notification, where, my lord, the recommendation was 11A, my lord. Though there is no change, yet, my lord, 11A, food grains and sugar. My lords get that, my lord? Sorry.
Which page?
202, my lord. 202.
Yes.
My lords get that.
Yes,
Sorry.
11A. Yes.
Yes, my lord. Food grains and sugar. 100% of food grains, 20% of sugar production may be reserved for packing in jute bags. So, my lord, no change from 2022. Shortage continues. Yet, my lord, they insist on this. Then, second, please come to, my lord, the bottom. Packaging of export commodities. Following D. Following may be kept out of the purview of reservation under the IPM Act, JPM Act. Packing for export commodities. My lord, if we have to export sugar, we shouldn't pack it in jute bags because, my lord, it is carcinogenic for, we, my lord, can get cancer. Foreigners should not. Permit me to read further. Fortified, my lord, sugar fortified with vitamins, exempted. Smaller consumer packs of 10 kgs or below, sorry, 25 kgs and below for sugar. 3. Bulk packaging of more than 1,100 kgs. Then sugar pack for export, but which could not be exported on the basis of an assessment and recommendation of the Department of Food and Public Distribution. So, my lord, what has happened is, though there was no change from 2002 to 2022 to 2023, there is a shortage. Yet, my lord, they say no change at all. 9 lakhs, 14 lakhs, 9 lakhs, 13 lakhs. And for export, my lord, you are exempted. For, my lord, vitamin sugars, my lord, exempted. Others exempted. Indians can get carcinogenic, but can get cancer, but outsiders, no. This, my lord, has not been taken into account. Ultimately, my lord, public, my lord, health is far more important than anything else.
This is applicable to 50 kilograms and
yes, my lord.
Between 50 and 100 kilograms. All other weight is
below, no, not 50, my lord. Below 25, 25 to 100.
So this D1 is for D1 is exemption or to be
exemption, my lord. So, D, my lord, following may be kept out of the purview of reservation at the IPM. Export,
sugar,
packing for
sugar. There will be no need to use jute bags for sugar fortified vitamins.
For export.
For export.
Export, For
And-
sugar fortified with vitamins.
X of 10 kilograms below for food grains and 25 kilogram below sugar.
Correct, correct.
Then bulk packing of more than 100.
100 kgs, my lord.
So except this, it will apply.
Correct. But then, my lord, we all take, my lord, what happens is we take from a sack. The shopkeeper will purchase, my lord, a 50 kg bag. It's in jute. All, my lord, it's carcinogenic. He'll, my lord, take it out and give it to us. He'll not take, my lord, 10 kg bags and do it. Or he'll take 25 kgs and then, my lord, distribute it to all of us.
Yes.
This was, my lord, in the year 2023. 2024, there is no, my lord, sitting of, my lord, the Standing Advisory Committee. Gujarat High Court has held, my lord, every year it has to be done. And, my lord, they have not done it, my lord, for 2024, yet the notification.
Advisory committee has not met.
No, my lord, after 2023, it's not met.
Yes.
2023, my lord, after that, no meeting. And please come to, my lord, page 17, sorry, at 118. Without any meeting of the JPC, my lord, the Standing Advisory Committee, therefore, my lord, without meeting of the committee, this is what has happened. It could not have been. My lord, please look at, my lord, the second unnumbered paragraph there, page 118. Notification of 28th of June 2024. Jute here is, my lord, 1st of June, my lord, to the 30th of May next year. 1st July, sorry. In the said order, in the preamble at para 4, the words and figures up to 30th of June.
So extended.
Extended. This could not have been done because there is no meeting of the JPC and no, SAC, no recommendation.
So extended without meeting of the committee.
Because the Act's mandates, there has to be a recommendation.
Where is that mandate?
Please come to, my lord, the Act itself, my lord.
Anyway, Lord, the quick answer is the 32nd committee has already met in May 24.
Yes.
They've already met. Recommendation is pending before central government.
I have got their notices.
So this
Then, my lord, if the recommendation is pending,
This
In
act-
May 24 itself, they have met.
According to you, this extension is as per the 32nd committee.
Yes, yes.
The extension is as per the 32nd.
32nd, I have got the records. 32nd.
We'll produce it, Lord. That we'll produce a copy of that minutes of.
So according to you, this extension as per 32nd committee recommendation.
If that's all.
One minute.
No.
Let us-
The extension is as per the previous one itself. My learned friend said that thereafter in 2024, the SSC has not met.
Extension is of previous decision.
Yes.
Of
yes.
30 seconds.
Based on the recommendations of the 31st.
31st,
Yes.
not 32nd.
32nd meeting has taken place in May 2024. Recommendations have been sent to the central government. The central government is yet to act on those recommendations.
Okay.
Then, my lord, this notification on the face. of-
First meeting is, where is the minutes, 31st meeting, which
31st is already before your lordship.
you should.
I have produced.
I
it, Lord.
read to you, lord. 31st, my lord, is page 197, which I read to you. lord.
Page 1.
So that recommended for use of.
The 31st meeting recommended 20% usage.
Recommended.
Correct.
Recommended.
Yes.
20%.
20% recommended by the SSC, followed by the central government through the impute notification.
That is now being continued.
Yes, that
Continue.
is now being continued.
And 32nd meeting took place, recommendation was made, but
Lord, I
Under
have,
consideration.
I have not yet received a copy of that because the central government has not acted on the recommendation. But the meeting has, the SSC has already met.
meeting was held.
Meeting was held in May 2024 are my instructions.
May.
They meet every year. Contrary to what my learned friend is submitting,
All right,
they meet
well, I
every.
stand corrected, my lord. In that event, this notification at page 118 could not have been issued. This is short.
This is all we are prima facie.
Absolutely. Absolutely, because then, my lord, if they have met and the central government, my lord, What recommendation, we don't know. Central government does not know. Central government has not passed any order. On the contrary, my lord, based on 23, if they extend it, it's contrary to the judgment of the Supreme, my lord, Gujarat High Court, and contrary to, my lord, the Act itself. This is a short question. Then, my lord, in fact, please come to, my lord, 197 itself. Andhra Pradesh, my lord, they have been saying, my lord, all the 212, my lord, if your lords come to
212.
Not 212, I say. Don't do all that. Please come to, my lord, running page. Sorry. Page 198, my lord. That notification of, my lord, SAC meeting.
190.
197, which I pointed out. In that, (198), if your lords come to. Punjab government has been saying, my lord, that the reduction in weight of jute bags from 665 grams to 580 grams has adversely affected the quality of bags. Therefore, further reduction in weight should be considered. She also emphasized for use of non-flammable jute batch oil in the manufacturing of jute bags. My lord, it catches fire. It's carcinogenic. So they have been saying all this. That is also not taken into account and consideration. Anyway, my lord, my submission to your lordships is, in the light of, my lord, the statement made by the learned ASG, Additional Solicitor General, the extension, my lord, on the face of it is, my lord, tenable.
Yes.
Then, my lord, Andhra Pradesh, please come to, my lord, 127 of the very appeal memo. Andhra Pradesh State Civil Supplies Corporation, my lord, it is, my lord, distributing sugar under through the ration cards, my lord, to the ration holders. This. This is a tender invited, my lord, by the Andhra Pradesh State Civil Supplies Corporation Limited. 127, my lord. Bids are invited. Bids are invited, my lord, please look at it. From the eligible bidders for supply of 17,535 metric tons of sugar, cane sugar, supplied in half kg forms. Now, my lord, please come to page 141. They say, don't pack it in jute bags, only polythene packs.
Yes.
Page 141, my lord, packing. Ultimately, my lord, it is this. My lord, health, Article 21. My lord, I don't want unnecessarily giving your lordships, my lord, we have given judgments, they have given judgments. My submission to your lordships is threefold. One, health, my lord, public health is extremely important. If it is carcinogenic, my lord, which they themselves, your lordship saw, my lord, in one of their meeting itself, it says, and Gujarat High Court also says it's carcinogenic, which, my lord, Jute Commissioner himself has said. Therefore, my lord, packing, my lord, is not of sugar, because food grains, my lord, we wash and eat. Sugar, my lord, is never washed. Therefore, my lord, public health is important. That's what, my lord, the learned single judge has noticed. Secondly, every year, my lord, there has to be, my lord, a notification, my lord, a SAC meeting, and they must recommend, and then, my lord, notification. In the instant case, 2024, nothing has happened. According to, my lord, the Additional Solicitor General, my lord, there's a meeting. What it is, we don't know. Central government, my lord, has not considered it. On the contrary, my lord, it extends the earlier one. Thirdly, my lord, my submission to your lordships is that there is shortage of sugar, my lord, jute. In fact, even now, there is a 20% shortage of, my lord, jute bags, because there has been floods in Bengal. And, my lord, a lot of jute is imported, my lord, from Bangladesh, not, my lord, manufactured by us. This is the report, my lord, of Jute production set to drop by 20% this year due to floods. My lord, there have been floods. So, my lord, what was 9 lakh? All right. Same thing, my lord, is also come, my lord, in Hindu.
I'll show you. Secretary, National Jute Board.
All right, all right. My lord, please turn the page over, my lord. I'll tell you, lordship. This is report of Hindu. If it is, my lord, it's a statement given by, my lord, Jute, National Jute Board Secretary. Next page, if your lordship turn. Shanti Bhushan Singh, Secretary, National Jute Board, reports the Hindu. Speaking to reports in Coimbatore, Singh attributed the fall to inclement weather, especially floods in West Bengal and Assam that have damaged the crop and affected the cultivation. So, my lord, it is 20% less.
Right.
Therefore, my lord, my submission to your lordship says, and my note, my lord, has all the comprehensive this thing. I don't want to repeat what is in my note, my lord. Extremely grateful, my lord, for the patient hearing, my lord, and the indulgence that your lordships have shown us.
Lord,
You are,
I represent ISMA, my lord, that is Indian Sugar Manufacturers Association. We have filed an intervention application. We are, my lord, the apex body for sugar manufacturers in the country. And in all these deliberations, my lord, before the Standing Advisory Committee, we are the ones, my lord, who have made representations on behalf of the sugar industry.
which is the IA number? 5. 5 of 20. Yes. So you are adopting the argument of Mr. Hall.
I more or less, I'm adopting the arguments. I don't wish to repeat. I'll, of course, very briefly summarize what has to be said. Lord, nobody, my lord, wants sugar to be packed in jute bags, except 2 entities, the Standing Advisory Committee and acting on that, the central government. Your lordship will see across the board, every state, every organization, and every study has shown that packaging of sugar in jute bags is neither beneficial to the jute industry or the sugar industry or to the general public at large. But nobody wants to waste money, my lord, or a food product. Sugar, my lord, is hydrophobic, so is jute, which means, my lord, it absorbs water. Therefore, the whole objective is, while transporting or storing sugar, one must ensure that water does not enter sugar, because then that's the end of sugar, really, as we know it. Because we can't wash sugar, my lord, because we have to retain it and sell it. And there's moisture in the air. So each of those has an effect on sugar in the same way, my lord, as it has an effect on cement or it has an effect on fertilizers. Which means, my lord, necessarily someone has applied their mind and said, if I ask cement to be packaged in jute packages, I'll get a cake instead of cement powder, my lord, which I can utilize. And I will contaminate fertilizer. Now, this issue, my lord, of contamination of sugar is not just about protecting the jute industry. It has to be viewed in contradistinction to protection of the people. Because so far as India is concerned, and India alone, 20% of the sugar that is sold is packaged in jute bags and sold across India. And we are mandatorily required to do so. Now, Lord, when we have pointed it out repeatedly every year to the Standing Advisory Committee that this has a carcinogenic effect, and just not us, of course not, if only we say it, one will say that you have a vested interest in ensuring that you don't want to spend more money in buying jute bags. But it is not just us. Andhra Pradesh, the government, Punjab government, and several other institutions repeatedly tell the Standing Advisory Committee that it is dangerous. It is neither in the interest of the public, nor, my lord, is it in the interest of the sugar industry, because there are problems of weight, problems of catching fire, and problems of moisture. Now, my lord, what is minimum required is for the Standing Advisory Committee to examine these three facts.
Which reflect moisture.
And moisture. Moisture, my lord, carcinogenic effect.
Which are the three factors?
Beg your pardon, my lord?
Which are the three factors?
Three factors, my lord, is moisture, the health on people, health, weight of the bags, weight of the bags. The weight, my lord, is far higher. And the danger of catching fire. And every one of the statements we've made is backed by material. It is not, my lord, statements in the air. These are statements which are backed by material. Now I ask myself, my lord, your lordship may see the 30th meeting of the Standing Advisory Committee or the 31st meeting of the Standing Advisory Committee. And please examine if there is even a consideration of one of these things. And your lordship will find that there's absolutely no consideration. Can I only request my lord to look at the writ appeal? I'll not trouble my lord by reading it extensively. Please take the writ appeal. And may I humbly request, my lord, to kindly come to page 120, which is the 30th meeting of the Standing Advisory Committee. My lords have 120. Please see, my lord, para 3 onwards. The objection of the government of Punjab is first.
Paragraph 3.
Paragraph 3(1). Representative Government of Punjab stated reduction in weight of jute bags from 665 to 580 grams has adversely affected quality of bags. No further reduction in weight should be considered. He emphasized the use of non-flammable jute batch oils in the manufacturing of jute bags and requested for an SOP for complaint lodging mechanism for defective jute bags, in addition to existing BIS inspection of entire lot. Claim of dues of defective jute bags may also be settled on priority. Then, Lord, the issue with Government of Madhya Pradesh next. I won't trouble you also by reading all of them. Government of Madhya Pradesh, Government of Chhattisgarh. Then on the next page, my lord, everybody says across the board there's shortage. Then on the next page, my lord, the representatives of Labor Department. Then Andhra Pradesh, again on shortage. Then, my lord, representatives of Indian Jute Mills Association, which I understand my learned friend is representing. Then Jute Balers Association. And then, my lord, the representation from us, point 8, Indian Sugar Mills Association. And we have pointed out specifically at point 8. Representative from Indian Sugar Mills Association and National Federation of Cooperative Sugar Factories submitted. Adequate jute bags are not available to pack food grains. Government has to dilute the reservation. Therefore, there is no need for any reservation of sugar to be packed in jute bags. Also, problems in quality is not restricted to material component, but also as other standards like length, width, weight, and price of jute bags. Hence, Representative Isma proposed 100% exemption from sugar from mandatory packaging in jute bags. Then, Lord, next is a representative from another association. Then please see para 5, my lord. Para 5 at page 122. keeping in view the submission made by stakeholders, chairman of the committee stated that there is always a shortfall in supply of jute bags in comparison to the demand, resulting in dilution in favor of HDPE or PP bags to meet the requirements of packaging material. Then jute commissioner submitted, average sacking production is around 9 lakh metric ton, and it is anticipated there will be a requirement of 14.3 lakh metric ton for packaging of food grains itself. There's nothing else, not sugar, only for packaging of food grains. In the year 22-23 by SPS and FCI, so the likely availability of raw jute would be so and so. Provision of 100% of jute bags to GM. Then, my lord, para 7, Director Department of Food and Public Distribution states what the issue is. And then, my lord, last 3 lines, he specifically says, sugar may be completely exempted. I don't know if your lordships found that. No, I'm sorry, it's not very clear in this copy. Last 3 lines, my lords. In para 7, last 3 lines. Sugar may be completely exempted from the mandatory packaging norms, and the relaxation powers exercised by the Ministry of Textiles may be excised from the present level of 30% of the procurement of food grains. Then para 8 on the next page. Para 8, my lord, on the next page, 123. Para 8, my lord, on 123. Chairman stated that it is a reality that the jute industry has not been able to fully cater to the demand of jute bags by the state procurement agency FCI during the last several years. Demand of jute bags increased year on year, while the production by the jute mills is same by and large, thus leading to a wide gap between the requirement and supply of jute bags. Our production of jute for 22-23 has been estimated to be even higher than the previous year. I mean, I must pause here for a minute. Last time, Lord, the learned ASC said that there was a shortage that year and therefore there was exemption. But the chairman notices there's actual increase in quantity, and then the recommendation is made saying at page 124, sugar may be exempted completely. But this recommendation is not adhered to by the central government. Central government still required not 20%. So my learned friend's argument last time was whatever the Standing Advisory Committee says, the central government then follows and gives effect to it is not correct. Where is it? Now, my lord, can I request my lord to kindly come to 197 of the writ appeal? (197), my lord. This is the 31st meeting. And I won't read all of this. I'll quickly
Please.
only highlight the point. That's all. I won't read it quickly. Only to the point that I'm trying to make now.
Don't repeat also.
I won't repeat.
Yes.
I won't repeat. I'm very conscious now of what my learned senior friend has said. I'm not going to repeat. I just want to point out to your lordships 3 or 4 facts here. Please see, my lord, 3.1 at page 197. I won't read it. Our objections. Representatives of Indian Sugar Mills Association. Our entire objections, my lord, are there. Then at the bottom, point 4, Sugar Department, Government of Andhra Pradesh. On the next page, my lord, Joint Secretaries statement. Then point 4, representative of the Government of Punjab. All the statements, my lord, are recorded. And then, my lord, point 5 at page 200. Identical quantity of sacking production continues at 9 lakh. Point 5, I'll just read 3 lines in that. Jute Commission submitted that the average sacking production is around 9 lakh metric ton. It is anticipated there will be a requirement of 11 lakh metric tons of jute bags only for packaging of food grains. Therefore, my lord, this whole dichotomy that they said, oh, there's a lot of production of jute and therefore there's overproduction, therefore sugar has to be packaged, in my humble submission, is really an incorrect statement. Because now after doing all of this, the only consideration is at para 11, which is really no consideration at all. The statements of everyone is recorded, and at para 11, the Standing Advisory Committee only says this much. After taking into account the deliberations and the facts submitted before the committee, SAC recommended the following commodity-wide reservation norms under the JPM Act 1987, 100% for food grains, 20% for sugar. Now, I asked myself, the entire purpose, as my learned friend, the AST said, the entire purpose of the SAC is to ensure that there is a consideration of all issues and then a determination made. If you on the one hand say there is a shortage, you recognize the shortage, accept the shortage, how do you then turn around and say, now I will impose 20% on sugar when the quantity of jute bags which are manufactured are not even sufficient for food grains? And this, my lord, is straight away accepted by the central government. The central government imposes it and then continues it. As my lord, senior friend pointed out, it was simply continued after that. And my lord, in this case, I want to point out to your lordships that from the year 2013, after the Rangarajan committee report, my lord, which was pointed out last time, which said that jute bags are not recommended for sugar at all, the CACP, my lord, has every single year said that don't use jute bags for sugar. I'll give you lordship the page numbers, my lord. I won't trouble your lordship. I'll give a list of the page numbers. But every single year, I can say without any fear of contradiction, that's the Commission for Agricultural Costs and Prices. And this is a statement that they make. I'll just read that now. I won't trouble you lots by asking you to take the book. Page. It's at page 191 of the writ petition. It starts at page 171 at page 191. Where is this? This is page 191 of the writ petition. Writ petition. Volume 1. Satish, volume 1. .12. Sorry.
Same report.
Yes, 171 is the price policy for jute for the 2013-14 season.
What is the part of this is what? This is
And it starts at 171.
some chapter,
Yes, ma'am.
some research.
This is a demand, supply and efficacy of price policy. No, this is the report of the Commission for Agricultural Costs and Prices of the Department of Agriculture and Cooperation, Ministry of Agriculture.
Committee on Regulation of Sugar Sector in India. Page 124.
Well, 124 is the report of Rangarajan report. I'm not reading that one because it's already been read to your lordships. I'm asking my lord to come to page 171.
171 is.
It's the Commission for Agricultural Costs and Prices of the Ministry of Agriculture.
Yes.
This comes out every year, my lord. Every single year, one report comes. And we produce it from 12 to 23. And at page 191, there's a specific reference to Rangarajan Committee and the fact, my lord, that it is not advisable for sugar. 191, 2.12. In 2.12, my lord, about 10 lines from the bottom of that paragraph. In the case of sugar, it is reported orders are anyway being flouted. It is therefore suggested that the compulsory packaging order 2.12, 2.12, about 10 lines from the top of that paragraph, my lord. In the case of sugar, it starts. It is reported orders are being flouted. It is therefore suggested that compulsory packaging order be revoked for the oncoming sugar season. Recently, Rangarajan Committee set up to look into issues relating to regulation of sugar sector has also recommended complete exclusion of sugar from the purview of JPM Act. While the Commission fully supports this recommendation of Rangarajan Committee, it also recommending relaxing the mandatory packaging requirements for food grains from 100% to 70 to 80%. Now, the point is only this, note. Standing Advisory Committee, of course, must examine, but it can't ignore all of this. This valuable material of experts in the field. It is not as if just the Indian Sugar Manufacturers Association or the South India Sugar Manufacturers Association is coming before your lordships and saying that it is bad. Everybody is saying that there is a health hazard. And everybody's statement not is ignored simply by saying at the very end of every examination in one paragraph that this is the recommendation we are making. Lord, this in my respectful submission. And my lord, I won't trouble your lordships, but every single report from 2013-14 till the last one of CACP is the same, that there is a need to stop compulsory, forcible imposition of jute bags on sugar manufacturers. And all of that is part of the writ petition. It's okay. What is it?
Yes.
One more point, my lord, I'm sorry. We had filed a memo before my lord last time on 20th of September 24 with some documents. There, my lord, the page 76. This, my lord, is the report.
This is filed by?
Filed by us, my lord. Respond number 1.
Are you?
By us, not by us. I'm sorry. My lord, I'm identifying myself with the original petitioners because our case is ultimately the same. But respond number 1 has filed it. Page 76.
Page 76.
76. This has, my lord, the entire quantum of jute bags available for supply from 2015-16 till 23-24. And my lord will see the first column. Please see, my lord, that table, total quantity of jute bags required for packing food grains. The next one was total jute bags manufactured is higher for food grains. opening stock from previous year, then total jute bags available, bags supplied for other commodities, then please see total quantity of jute bags supplied for food grain. It is lower, my lord. As your lordships will see, it is lower than the quantity required for even packing food grains. If my lord sees the last 3 years, 21-22 is 15.31. Quantity available is only 7.93. Then 14.3 and 8. 13.6 and 8.5. When, my lord, I ask myself, the Standing Advisory Committee knows there's a shortage. Despite knowing there's a shortage, there's a direction to reserve 20% for sugar. Can that, in my respectful submission, be sustained at all? And food grain, of course, has been kept separately from sugar. Food grain and sugar have not been mixed up. They said food grain is 100%, sugar is 20%. And they all recognize that the quantity of jute bags available is not even sufficient for food grains.
Yes.
And last submission is only this, I'm so sorry, last submission on the basis of the Act.
Every additional submission now will curtail his submission.
Yes, ma'am.
Yes. No, every more submission by Mr. Chinnappa will curtail your submission.
I will invite it, Lord, because he's.
That is how I curtail.
I will be very short. I will be very short.
It's okay.
Yes, yes.
I will not take more than 2 minutes.
Yes, yes.
Lordship may curtail both their submissions by 2 minutes. My lord, please see section 4, and I won't say anything more, of the Act. The Act, my lord, I had given separately.
Page 4 in my company. In the company. It's a separate company. We did not produce the Act with the written, with the judgments.
Please see 4.2, my lord, what the Standing Advisory Committee must take into account.
4.2.
4.2. Standing Advisory Committee shall, after considering the following matters, indicate its recommendations to the central government, namely, 1, existing level of usage of jute material, quantity of raw jute available, quantity of jute material available, protection of interests of person engaged in the jute industry and production of raw jute, need for continued maintenance of jute industry, and quantity of commodities which is likely to be required for packaging in jute material. I ask myself, my lord, and I think the answer is fairly obvious from a bare reading of the report of each of the Standing Advisory Committees, that there is no consideration of any of these matters. And the absence of consideration, my lord, in my respectful submission, is a straight ground to interfere with the decision of the central government, which has been taken on material which does not exist. I'm very grateful, my lord. I'm sorry I took that extra 2 minutes.
Lord, the respondent writ petitioners have premised their arguments on the so-called issue of public health, particularly on the ground that usage of jute bags would lead to a carcinogenic effect. My first formulation before my lord says the writ petitioner should not be allowed to raise that issue because they are raising it for the first time. They have not raised it before the SAC. May I take your lordship through the minutes of the SAC, both 30th as well as 31st, where the body represented by my learned friend, Mr. Dhyan, had an opportunity to represent before them. Let us have a look at what are the issues that they raised before the SAC. Lord, please take up the writ appeal volume and straight away turn to page 120, which is the minutes of the 30th Standing Advisory Committee's meeting held on 21st of July 2022. The submission made on behalf of the ISMA, that is Indian Sugar Mills Association, can be found at page number 121. Roman number 8 at page 121. Where one of their representatives who attended the meeting, he raised certain issues. If I may read the issues raised by them, the representative from the ISMA and National Federation of Cooperative Sugars Limited submitted that adequate jute bags are not available to pack food grains and the government has to dilute the reservation. Therefore, there is no need of any reservation for sugar to be packed in jute bags. Also, the problem in quality of jute bags is not restricted to material component, but also other standards like length, width, weight, price of jute bag. Hence, the representative ISMA proposed 100% exemption for sugar from mandatory packaging in jute bags. No issue of batching oil, no issue of cancer, no issue of public health. None of the issues that which my learned friends have now raised. Now, please have a look at the latest one, which was held last year. There, a little more elaborate submissions were made, which your lordship will find at page 197. In the red typical volume, page 197. The representative from ISMA and National Federation of Cooperative Sugar submitted the following. Lordship got page 197. From A to H. Page 197, Lordship got it.
197.
197. A, large gaps in jute bag allow leakage of sugar and moisture regain. Hence, please have a look at this because this deals with the moisture. Hence, the possibility of fibers getting mixed in sugar which affect the quality of the sugar pack. So what they are contending is that there are gaps in the jute bag which allows leakage of sugar and moisture regain. And what does it lead to? It leads to possibility of fiber getting mixed in sugar, which affects the quality of sugar pack. There is no mention about, say, looping or clustering or contamination, which the learned single judge uses. They say moisture will lead to fiber mixing. Then let us read the rest of the submissions made. B, bad quality of sugar attracts penalty from FSSAI. C, hygroscopic nature of jute bag deteriorates sugar by formation of lumps and loss in color, whereas plastic bag absolutely avoids air and moisture. Hence, jute bag is not the best option for packaging of sugar. Packaging of sugar in diversified jute bag does not serve the purpose in total, and this is not accepted by customers. Sugar season for last 6 months, and sugar produced in these 6 months is sold in the next 2 to 12 months, 14 months. Therefore, in monsoon season, jute clothing being porous attracts moisture from air and sugar becomes moist, thereby falling below ISS grade, resulting in reprocessing, causing huge financial loss. In the international market, PPHDP bags are adopted as a practice for packaging of sugar. By making jute packaging mandatory, the sugar exported to different countries will be affected, causing huge economic loss. During the last 10 years, in comparison to increase in food grains and sugar production, the production of jute bag has remained almost unchanged. Hence, jute industry is not able to meet the entire combined demand of sugar grains and sugar. And finally, a 50 kg jute bag approximately is 55 to 60 rupees against the cost of rupees 23 to 26 for PPHPP bag. If sugar is packed in jute bags, the ultimate burden of higher price for sugar will come over to the customers. Keeping in view the above explanation, sugar industry proposed 100% exemption for sugar from mandatory packaging jute bags. So Lordship will notice there is no mention of effect of the batching oil or the carcinogenic effect, which my learned friend spent a substantial time on that aspect, and he referred to various material and of cancer. So when they have not raised it before the expert body, can they be allowed to raise it before a court of law for the first time? My respectful submission, they should not be. I will deal with Gujarat High Court in due course of time. The second issue was that it leads to moisture, which is already covered. For that, my lord, my respectful submission is currently there are bags available with lining, which can be used, which prevents moisture. So there is an option available to which also meets their requirement. The emphatic submission on behalf of the respondent was that the SAC is not considering the recommendations made by the ISMA. But my respectful submission, my lord, is that is not true. Prior to the 30th meeting, there were no exemptions. In the 30th meeting, the SAC recommended certain exemptions. Please have a look at those exemptions, which means that the responsibility gets reduced. At page 124 of the 30th recommendation, 30th minutes of the meeting, there are certain recommendations made at page 124. That is, certain things are kept out of the purview of the reservation. What are they? There were 3 items which were kept outside the purview of the reservation, which shows that the central government as well as the SSC were alive to the request made by ISMA. The first one was packing for export of commodities. We completely exempted application of jute bags. So which means that their entire export requirement was exempted. That is in addition to the 80% exemption. Over and above the 80% exemption, we have exempted exports. Number two, small consumer packs of 10 kgs and below for food grains, that is not applicable to them, but in the subsequently we do it, and bulk packaging of more than 100 kgs. So any sugar packed for more than 100 kgs was also accepted. My learned friend, Mr. Holla, read about various bulk purchases like Parle, other corporates. For all of them, sugar is supplied in bulk and there is no scope for supplying in jute bags. All of them are exempted. So therefore, I don't know what case that is being made of. Now have a look at the further improvisation in the relaxation in the reservation in the 31st recommendation, which your lordships will find at page 202. Page 202, it is relaxed further. The bottom part of page 202. A new addition is sugar fortified with vitamins. Another new category is exempted from application of the jute bags. Earlier, this smaller consumer package of 10 kgs was for food grains, and now we have allowed 25 kgs and below for sugar as well. And then bulk is continued, and there is one more addition. Sugar packed for export, but which could not be exported on the basis of an assessment and recommendation by Department of Food and Public Distribution. So there are 3 more items which are added in the 31st recommendations. So this shows that the central government as well as the SSC have been alive to the suggestions made and they have considered it. Well, these sugar mills are making a big hue and cry about the difficulties faced. But my lord, they're not realizing the fact that the restriction is only to 20%. My lord, all this 20% will go to the public distribution system. They don't have to give it to their corporates or anybody. It will go to the public distribution system. 80% is exempted. And then, my lord, there is a about 1,500 pages of documents have been filed by the writ petitioners. All of them put together would either fall in the category of a policy or a recommendation. My lord, that is completely outweighed by the plenary law, which imposes a mandate on me. I cannot go by policy. There is a mandate by the plenary law. When there is a plenary law which mandates me to impose restrictions, that will outweigh all policies. So therefore, that entire bulk of 1,500 pages of documents which they have filed, my lord, would not be of any help to them. Section 3. Section 3, my lord, I'll read for your lordship's benefit once again. May I take your lordship to section 3. Please look at the sweeping provision of scope of section 3. It begins with a non-obstante clause, notwithstanding anything contained in any other law for the time being in force. So it excludes plenary law, let alone any delegated legislation like a policy. Notwithstanding anything contained in any other law for the time being in force, the central government may, if it is satisfied, after considering the recommendations made to it by the Standing Advisory Committee, not by Rangarajan or any other committee, that it is necessary so to do. Lord, please see what is the interest. In the interest of production of raw jute and jute packing material and of persons engaged in the production thereof, by order published in the official gazette, direct from time to time, though there is no requirement to do it annually, from time to time, that such commodity or class of commodities or such percentage thereof as may be specified in the order shall, on and from such date as may be specified in the order, be packed for the purpose of its supply and distribution in such jute packaging material as may be specified in the order. My learned friends referred to certain European regulations. Lord, Europe does not have jute. They don't have a statutory mandate to protect jute manufacturers. They don't have a mandate to protect people involved with jute manufacturing. Here we have 40 lakh people who are associated with jute manufacturing. We have a statutory mandate to protect their lives. So which is why, my lord, all these 1,500 pages of expert opinion and other recommendations will clearly be outweighed by the statutory mandate that I have to perform. Lord, the next big submission that was made on behalf of the respondent was by referring to various committee recommendations as also the SSC committee findings, is that there are shortage of bags. The shortage of bags already is taken care of. It will inure to their benefit. Please have a look at the 31st recommendation at page 202. We have made a very specific, the SSC has made a specific provision for that. Would your lordship kindly turn to page 202, item C under 11. There is a specific provision for shortage which will protect their interest. 11C, that C was not read out, my lord, earlier. 11C. Further, in case of any shortage or disruption in supply of jute packaging material, or in case of any other contingency or exigency, Ministry of Textiles may, in consultation with user ministry concerned, allow further dilution of packaging material up to a maximum of 30% of the total procurement. So if there is shortage, the textile ministry will reduce from 20%, they will dilute it further below 20%. I'm sorry. The Ministry of Textiles will reduce it. If shortage is flagged, if it is brought to the notice of the Ministry of Textiles, they have the power to, in a given, for whatever given reasons, they will reduce the liability. Let us say, for example, ISMA makes a recommendation. Sir, for this year, we don't have jute bag. What to do? Please dilute. Then from 20%, they may dilute to say 13%.
State procurement agencies or FCI. The next two words, state procurement agencies or FCI, no one else. It's not for
Yes,
ISMA.
but ultimately they are going to supply to them.
No. Sugar we don't supply, sir, as part of PDS.
The ISMA can supply to them. ISMA can supply to them. ISMA supplies to them.
But it's.
Yes.
That is true, but it's only to SPAs or FCI. My learned friend said, ISMA can then make a request and there'll be a reduction. It is not so. It is only for state procurement agencies or FCI. That is Food Corporation of India, which doesn't have anything to do with sugar.
No, but they supply to SPS and FCI. It is not their case that they don't supply to SPS and FCI.
They don't supply. We are not supplying. Only private.
Lord, my next submission.
Distribution system, no sugar is.
Lord, my next submission would be in reference to the Gujarat High Court judgment, not the Honorable, the facts in the case before the Honorable Gujarat High Court was different. There, my lord, although the SSC recommended 70 to 75%, the government went ahead and made it 100%, which is why, my lord, their lordships observe, if your lordship would take up that Gujarat judgment, my lord, para 35. Para 35 of the Gujarat judgment. It is contended by learned senior advocate so-and-so that looking to the prayer of this petition, even the petitioners have prayed for 70 and 75% reservation for sugar and food grains industry. And therefore, there is a need for reservation even as per the petitioners. And what percentage is to be fixed is a lookout of the central government. And this court will not take a decision in judicial review. This contention is also not accepted by this court, mainly for the reason as stated here in above, especially when the factors which have been considered by the central government are extraneous consideration. The reason given for brushing aside advice of the Standing Advisory Committee for 70 and 75% for sugar and food grains industry and for fixing 100% of the total production of sugar and food grain industry is based upon the commitment of UPA government and policy for the last year, that is jute year 2015. These reasons are dehors section 3 and section 4. Lord, under section 3, we have to follow the recommendations of, we have to consider the recommendation of SSC. If the SSC recommended 70 and if the central government made it 100%, it is clearly not following. So therefore, the Honorable Gujarat High Court was justified in interfering. My next submission is there is no mandate for the SAC to meet annually. It only says, section 3 says from time to time. And the learned single judge, one I'll conclude in just with 2 points. Please have a look at the learned single judge's impugned order at page 24 in the writ appeal. Page 24 in the writ appeal. Lord, para 6 is relevant for your lordship's consideration. Sugar is highly sensitive to moisture, which can cause it to clump, harden, or dissolve. Not this dissolve, even the ISMA doesn't say, thereby affecting its quality and shelf life and potentially leading to contamination. Not so, therefore, the first reason that the learned single judge finds a prima facie case is contamination. Please have a look at the second one. Since jute is porous material and can absorb moisture from the environment, and the batching oil which is used for manufacture of jute bag is tomerogenic, which means carcinogenic, the petitioner has made out a prima facie case for grant of interim order. So these two findings by the learned single judge, contamination and carcinogenic, were never raised before the SAC.
Causes tumors. Causes tumors. Tumorogenic.
It says these were not issues raised before the SAC. Where did the learned single judge get it from? Lord, an issue which was not raised before the SAC, can it be raised? And Lord, how could this learned single judge accept such scientific and technical matters? And my Lord, I would just 2 more points. The petitioners have not made out any error in the procedure of decision making. Lord, I have followed the recommendation, section 3. And finally, my Lord, the SAC recommendations are not under challenge. I heard my learned friend say that the SAC did not do so, so and so. The SAC decision is not under challenge. They have challenged only the notification. The recommendations of the minutes of the SAC. The SAC minutes are not under challenge. They are saying that SAC has not considered their submissions. The minutes of the SAC, that is the Standing Advisory Committee, is not under challenge before your lordship. It is only the 2 notifications which the central government has issued. Therefore, my lord, the learned single judge was clearly wrong in granting the interim order. I am grateful to your lordship.
The 30th SAC meeting was on 20.
This is Mitra, senior advocate from Kolkata. From Kolkata.
To protect the jute industry, I've come from Calcutta. Where after all, around 80% of jute is in Bengal and partly Assam, partly Andhra Pradesh also. Well, the 30th SAC was on 21st July 2022. And the 31st is on 26th May 2023. After 21st July 2022, 30th SAC, notification is published by the central government, which was on 31st of March 2023. Notification is published by the central government, not accepting the recommendation of the SAC, but directing 20%. May I hand? I can just give it.
Please give. I'll hand.
And give them copy. On this was lordship can see the very third paragraph, whereas the central government, after considering the recommendations made by to the Standing Advisory Committee. This is 31st of March 2023, third paragraph. This is not challenged by the sugar industry, even though this was the time when the central government overrides the notification. And Lordship kindly sees the fourth paragraph just above the table. This notification, like this year's one, up to 30th June 2023, just above the box. This was still 30th June 2023. No, not been challenged. There was a separate SSC. Well, this was the one based on the 30th SSC, where the 30th SSC's recommendation was sugar exempt. This is extended twice. Twice. This was not challenged also. This was first extended on 14th June, like this time. This was this time also. Lordship kindly sees this is on 14th of June. Extension. 2022 recommendation, notification in 2023 March, like this time, up to 30th June, extended till 30th September. Still they don't challenge it.
Then is September.
Then this is extended again, Lordship.
What he has given. Yes, that is challenge because it's extended without.
December is challenge.
Yes.
26th,
December is.
31st March is not under challenge. 31st March 23. Under challenge is the notification of 26th December 2023. 26th December 2023, and that is page 115 of the union's appeal. And the other is extension of that, 28th of June, page 118. June 2024. 28th of June 2024. It's earlier year. 14th June 2023 is the extension of the earlier notification of 31st March 23, which I handed up to my lord. So the 30th SSC is leading to no challenge. No, not 14th June. And the next page is also the 26th September. There are two extensions of that. They were extended twice, once till September 2023 and then till December 2023. No, well, there's no merger here. Now, my lord, as Mr. Holla rightly pointed out, there has to be a fresh recommendation. The fresh recommendation, so the earlier recommendation 22 merges in the two notifications, in the three notifications of May 23 as extended on 14th June and 26th September. Then comes the 31st SSC. Page 28, 6, yes, that is page 118 of the appeal. That is the extension of the 26th December. Now, so the ones which were really going against the Standing Advisories Committee's recommendation, which was made on 21st July 2022, they chose not to challenge. And as Mr. Holla rightly pointed out, it's that recommendations are on a periodical basis, maybe annual, maybe. So the 21st July 2022 recommendation came to an end with these notifications. Then comes the fresh recommendation, the 31st SAC, which is 26th May 23, which is page 190. And that is followed by the notification of 26 December 23. And like last year, it is also extended once, because till the 32nd comes, I mean, is implemented, this is extended. Like last year, it was extended.
120 is not right. Even the 26/12/2023 is also challenged.
Yes, 26/2023 is challenged. That is based on the 31st SSC. That is challenged. 31st SSC recommendation and the notification are in sync. The 20, so that is under challenge. But they are saying, but their cases, the 30th SSC was saying sugar exempt. That is July 2022. So how can this notification of December 23 be made? No, because the 30th SSC was followed by a notification of 2023 March, which was the one where the recommendation was not accepted by the government, and they went against the recommendation. Like a recommendation is not binding, so they went against. And the sugar industry was happy with it. And 2 extensions. And my lord, so this year's recommendation and the notification are in sync. And one of the most interesting and if I may say so, is the ironic part is this is not a fight. This is on the score of carcinogenic. This is not a fight between sugar and jute. Jute is carcinogenic and sugar is not. It's a fight between plastic and jute. They are supporting the plastic industry. HDP, they want HDP, and they are saying plastic is not carcinogenic and jute is carcinogenic. This is the irony of the submission. This is plastic versus jute. So pack in plastic. And that is the reason which was considered at the last, in fact, at the last SAC of the one they are relying upon so heavily is the no, not relying upon so heavily. That is the 31st SAC. Lordship kindly sees page 190 at 210. At 202. This is noted. The eco-friendliness of jute. The eco-friendliness of jute is noted at page 202. That jute is biodegradable and eco-friendly fiber. And they are saying, if this is carcinogenic, then what is plastic? Plastic may not cause contamination to the sugar, but to the environment, that's much more harmful. And Lordship, Mr. Holla submitted. Food grains, let them be packed in jute bags. Even if it's carcinogenic, you can wash and you will wash and use. Food grains include wheat. Wheat is 100% packed in jute bags. Wheat is not washable. Rice may be washable. Wheat is not washable. So wheat, let the wheat eaters eat carcinogenic product, but the sugar growers who are the sugar eaters will not. And at the cost, that is really all I have to submit.
Yes, ma'am. Yes.
I'm grateful.
Great.
Balu, one more thing, Lordship. I only wanted to give the notice of the 32nd SAC, which was given on 25th of July, even to sugar industry.
And they
They
attended the
participated
meeting.
in the meeting that was held on 30th of July. So this I'm giving them copies.
Yes.
No, 32nd.
Of 2024, that is for the 32nd SAC.
The
Lordship will see the 11th, the 19th notice. The 19th notice is the Indian Sugar, ISMA.
meeting
us-
notice for the
This
latest.
is the 32nd SAC, their recommendation is made and the Union of India will act on it. And the 19th notice is ISMA. Yes, so they attended the 32nd.
No, the
The
Impleading-
intervener.
the
Lord,
intervener.
Lord, should I amend the cost title, my lord, if your lordships are allowing? Lords, if lordships are allowing the intervening application, should we amend the cost title? I'm glad.
Extension could not have been granted.
Last year it was done twice.
A past illegality does not cure a present illegality.
No, but I put it all in writing, my lord.
No, Balu, one more thing, no notice.
Very
given to
grateful,
us.
very grateful.
One humble submission, madam. Serial number 100, madam. Place for a short accommodation, madam. Senior counsel has been engaged in it. Is unable to.
In respect of that,
This is the doctrine of pleasure, my lord, and in
doctrine of
taking adjournment, the similar case, your lordship has already decided. This was with regard to the
here
same.
the term is over.
Here, the term is not over, but by virtue of the interim order, they have continued for almost a year and a half, my lord.
No,
And
the
knowing fully well that
term of the body is over.
this is not a body, my lord. This is a chairperson who is appointed as per the Central Relief Committee. Now, the Central Relief Committee, under the Beggary Prohibition Act, the statute itself incorporates the doctrine of pleasure. So knowing fully well that it is a post created by virtue of a doctrine of pleasure, after the new government came in, they cancelled the appointment of all these chairpersons and directors. Therefore, by virtue of an interim order, they have been continuing, and that cannot go on because we strongly object. We have filed a vacating of stay also. And this is the umpteenth number of time that this matter has come up and it's not been heard. In fact, the AG had argued the matter.
Yes.
My lord, we are ready with regard to the matter.
Any date may be given in this week.
This week, 26th.
26, my lord, as a last opportunity so that,
26 at 2:30.
please.
26 at 2:30.
Much of interim order may can be based on.
This is the interim.
Stand out to 26th of September to be listed at 2:30. Full stop. Interim order granted earlier shall continue to operate till the next day.
Much obliged, my lord.
Obliged.
This is number 96 for withdrawal, Mr. Govind Rai Kamar, K.
For the complainant, Your Lordship. Your Lordship, we had filed this withdrawal memo on the 10th of September, Your Lordship. Your Lordship, there's an amicable settlement arrived at by the complainant and the respondent number 4 in the WP number 84642 of 2016. The accused herein are the.
Learned advocate for the complainant, Miss so and so invites secretary to the court to the memo dated 10/9/24 filed by her and which figures filed her, which figures on record in which it is stated inter alia that the parties have settled amicably their dispute outside the court. And in view of the settlement, the complainant does not wish to continue with the contempt proceedings. In view of the above memo, the contempt petition is disposed of as not pressed.
Grateful.
Number 97. The
Your
Kavita.
Lordship, I appear for the complainant in this matter. I filed a memo on 27th of August, Your Lordship, for withdrawal of the petition.
You are also withdrawing?
Indeed, Your Lordship.
In view of the memo dated 27/9/24 figuring in report, whereby the learned advocate petitioner seeks permission to withdraw the petition, the petition is disposed of as withdrawn.
Number 98.
Your Lordship, 98, I appear for the complainant. I filed a memo on 27th August, Your Lordship.
Same.
This is number 99.
Your Lordship, in this matter,
regard to,
last time your Lordship must know what is the grievance of the petitioner. It pertained to the bad maintenance of roads have not been hospital and kindly see the order of this honorable court passed on
Lord,
3/6/2021, your Lordship.
the issue is.
The first order which was passed by this court, annexure E1 to E9, the photographs, kindly see the order dated 3/6/2021, your Lordship. The first order which was passed 3/6, your Lordship. Based on that, the 3/6, your Lordship.
3/6, yes.
Three six, your Lordship. Lordship, may I read, your Lordship?
Potholes on the public street.
But this
Okay.
matter was, while dealing with the potholes also, this court felt this also should be addressed under 332 of the BPP Act, new Act. So based on that, the subsequently reports were filed, your Lordship. The last order on 1/7/2022.
We have released
Now
the
they issued
amount.
work order.
The BBMP has given issued a work order also.
Now,
Based on the work order, my lord, nothing survives for consideration because the work
in the
will
light
get
of that,
done.
it can be disposed of.
First of will pass you.
Please, my lord.
Where is your
Memo.
counter?
A memo has been filed placing the work order on record, my lord.
Very-
It is
very good.
dated 2/3.
On 7/3/2024, your Lord. 7/3/24.
7/3/2024.
May pass on this copy, your Lord. Photo.
7.
Page number 12, your Lordship, 1-2. It's based on the CM's Navaratri program. Now the work order has been issued on 27th February 2024.
It is on page 12.
In
Disposed.
Much obliged.
Thank you very much. Write down the appearance.
This list one, contempt matters, seal number 2. The Chamrajam.
I am appearing under for complainants, Millers. Complaints file this complaint.
Notice
and-
returnable on. 29th of October.
Please.
Seal number 3,
Same. Please. 29th of October.
seal number 4.
30th October.
Contempt petition, my lord, sir, order is correct. They have complied to order, my lord.
Supplied with.
Yes.
Learned educated forum, learned Miss Hiramat Akka Mahadevi stated that the order under contempt is complied with, therefore the contempt petition does not serve, it is disposed of accordingly.
Nice. This number 5, Mr. Shekhar L. Mr. Shekhar L.
No, there can be on vacation. Learned educated is not present in the second session. Spend over to 28th of October.
Number 6,
Notice written on 29th October.
obliged.
number 7,
I appear for the complaint, my lord.
Subramani.
Annexure A is the order.
Notice written on 28th October.
Obliged.
Next.
Number 8, Mr. Srinivas K.
Appear for the complainant.
Returnable on 28th October.
9, dispose, seal number 10, Mr. R.B. Sadashivappa.
Complainant.
Ten.
The impugned order, my lord, finds it on page annexure A.
Notice written on 22nd October.
Please.
Seal number 11, Mr. Chaitanya S.G.
Lord, this is regarding the appointment of chairperson to the RERA Appellate Tribunal, my lord. The post has been vacant since 1 year, my lords, and they have taken an undertaking that within a fortnight they will appoint the chairperson. And accordingly, a direction was issued, my lord, by the
What is the interim order granted?
my lord,
Read paragraph 6 on page 15.
yes, my lord, as per section 52 of the RERA Act. My lord. The government is to fill vacancies and the proceedings are to be continued from the stage at
So you are concerned with direction in paragraph number 4. With a direction to respondent state to appoint the chairperson within 4 months.
My lord, pardon, my lord, sir.
Which direction you want to enforce?
My lord, in the order sheet, para number 4, my lords.
Read it.
In the light of the said submissions, the prayer in the writ petition number 1859 of 24 seeking constitution of tribunal is rendered infructuous. Therefore, WP stands disposed of having become infructuous with a direction to the respondents state to appoint the chairperson within 4 weeks from the date of receipt of the copy.
What is the interim order which is mentioned in paragraph 6?
My lord, interim order was not granted in this matter, my lords. It was in connected matters. There was no interim prayer at all, my lords, in our case.
Notice 29th October.
Grateful.
December 12 to Ian Nanja ready?
Notice 28th October.
November 13 to case Mallikarjunaya.
Petitioner,
Notice 29th October.
already they appeared, my lordship. Murugesh is already filed wakalat.
Already complied with.
Yes,
No,
Complied.
not complained.
not complied. We have challenged the order of the learned single judge, my lord, by filing a writ appeal. Not 945 of 2024 is filed.
On that day, will tell.
Please, please.
But in this, there is no stipulation of time, my lords, in the control.
Lordship, they themselves as recommended by board resolution. And you see, this is a
Notice by me. There is no time. It is. This is for refund of some amount.
Lords, if at all they have withdrawn the amount, then they will have to deposit and they'll get.
we have
back the
not
land.
taken any money, but they have deposited.
So here, appeal is filed.
I have filed an appeal.
Who are you?
I'm Bangalore Development Authority.
Learned advocate so and so, the respondent number 2 Bangalore Development Authority stated that the lead appeal is filed against the order dated 28 February 2024, passed in writ petition number 4934/21, which is the subject matter of the present contempt proceedings. In that view, the present contempt petitions shall be listed along with the appeal.
Please, great.
Number 14 to A Nagarajappa.
Order has been complied now. Order has been complied.
Learned advocate so and so stated that the order brought under the contempt is complied with, therefore nothing survives in the contempt petition, it is accordingly disposed of.
Number 15 to Nataraj Balla.
State in this matter.
Notice written on 29th.
Number 16 to GR Mohan.
Notice written on 28th.
Number 17.
Notice written on 29th. Complied with.
No, not complete.
PAL matters, cell number 18 to JR Mohan.
Very for petition in this case. My lord, in this writ petition, I have sought for a direction to the respondents to fix the road spots and to repair the road. My lord, the road between Kushanura and Bavalgaon of Avrattal is a district head highway. This road passes through the villages called Karakyala village and Karakyala cross. The distance between these two villages is just 1 kilometer, my lord. But this road is full of road spots. It is highly impossible for the commuters to pass through this road, my lord. I have actually produced the photographs showing the road full of road spots, my lord. So this is a district highway. This is the condition of the road, my lord. Because of this road, the people of the locality have been facing much hardship, my lords. Further, there are chances of causing accidents because of these roads. The pathetic condition of the road is clearly visible, my lord, in the photographs. In fact, I made a representation to the authorities. But the next year, my lord.
Present petition is filed, styling it as a public interest petition. The prayer made by the petitioner is for directing the respondents to fix the road spots and repair the road between Karakalya village and Karakalya cross, over AURAD, Taluka Bidar district, by considering the representation dated 3/10/23. It is the case paragraph of the petitioner that the road between Shanura and Bawala, BAWALA, Bawala Gaon of Aurad Taluka Bidar district, the district highway. It passes through Karakalya village, Karakalya cross of Aurad Taluka. The distance between the Karakalya village and Karakalya cross road is stated to be only 1 kilometer. Paragraph. It is the grievance that on the said road and there are innumerable road spots. The road spots are having road spots full stop. The road, then again the road spots have been causing serious hardships in the commuters. Petitioner have stated that a representation dated 3/10/23 is made to the respondents requesting them to fix the road spots, to repair the road and bring it into proper condition. The petitioner has further stated that respondent 2 has given reply to petitioner's representation. Petitioner stated that respondent 2 has pursuant to the representation, directed respondent 3 and 4. Respondent 2, the chief engineer of the irrigation of the public works department, has directed respondent 3 and 4, who are the superintendent engineer and executive engineer, to take action in the matter. However, no action is taken, therefore the writ petition is filed. Therefore, the public interest petition is filed. First, having regard to the subject matter, the grievance raised, and the very prayer made, no further relief can be granted to the petitioner except requiring the competent or requiring the respondents to consider the representation of petitioner, which is admittedly pending, in its letter and spirit. Therefore, this petition is disposed of by directing the competent authority respondents to consider the representation of petitioner and take necessary remedial action to redress the public grievance of the petitioner.
Much obliged.
The petition shall be, that's all. I think.
Number 19, to J.R. Mohan.
My lord. In this writ petition, my lord, I have sought for a direction to the respondents to provide the basic amenities to Kamalanagar,
Same
Bidar
order.
district.
Will pass the same order. Representation.
Much obliged.
We decided expedient and steps shall be taken, steps will be taken.
Number 20,
My lord, I appear for the petitioners in this
Yes,
case, my
please.
lord. My lord, I am
This is
appearing for the
which
petitioner in this case,
area?
my lord.
Which area?
This is in Kodagu district, my lord.
Sorry?
Kodagu district,
Kodugu.
Coorg.
Is
You
it
go-
North
the-
Karnataka?
My lord,
Issue notice returnable on.
my lord, I sought for the interim order, my lord.
We don't,
My lord, there are,
think trees,
my lord,
interim order will not carry.
my lord, there are already given the permission to cut the trees, my lord, by misrepresenting, stating
They
that.
are cutting the trees where, at which places?
My, in Kodagu district at Kusalnagara taluk, your lordship may kindly, I request your lordship to kindly turn to annexure L, my lord. Annexure L, in that typed copy, my lord, they are
Page-
wrongly interpreting that particular land, tenure of the land is a Paradina land, whereas Paradina land and all. Because in Kodagu, my lord, Kurg district, there are various tenure of lands, Jamma Bane and Sagu and Jagir and all.
What is paradigal land?
That is what, my lord. There is no word called Paradina either in the Karnataka Land Revenue Act or there is no notification issued by the government of Karnataka. And they are wrongly interpreting from Jamma Bandal. Suppose I sell the Jamma Bandal to any person, my lord. While entering the revenue entries, they will enter it as a Paradina land. Suppose if it is Jamma land is sold, then automatically while transferring the kata, this should be a Jamma land only. They are wrongly interpreting, and you lords may kindly appreciate at annexure L, my lord, they have stated in, they have given the permission, my lord, to, whereas in annexure K, my lord, my lord, the annexure K, they refused to give the permission stating that cannot, cutting permission cannot be granted. Whereas the deputy conservator of forest, my lord, stating that it's a Paradina land and they have given the permission to cut the trees and even that to rosewood trees, my lord, and other trees. So I request you lordship to kindly pass an interim order because already there are in several places. My lord, if the, and there is a timber mafia is in the Kurg, my lord, Kodagu district. Whereas if this is continued and another disaster will taken place. My lord, this,
They are cutting the trees for sake
My
of
lord.
cutting for some purpose.
my lord, if they already given the permission, my lord, and if it is not stayed, my lord, it is like Wayanad, very recently what the disaster has happened. The same thing will also happen, my lord, and during 2018, there are landslides has been taken place in Kurg district. My lord, more than lakhs together trees will be cut, my lord, if the stay is not granted. Then the timber mafia is going on in a large extent, my lord, large scale. And moreover, my lord, they are interpreting wrongly as Paradina land and they are giving permission. You ask me, I request you also to kindly page number 228, my lord, where the additional district commissioner has given the finding. All the survey numbers are revenue land as per above mentioned Jabamandi document. The consent file has been sent for further action with the opinion that the owner of the land has no right over the trees in the said land. At page number 228, my lord. Despite all that, my lord, the
The permission. is
deputy
only till
conservator of forest,
5
Madikeri has division.
2024. My lord gets it at page 249. Page 249, the
Yes.
permission was only till 15th May 2024.
Yes.
Which has since expired.
So,
My lord, interim order, my lord, that he's asking for.
No, this is one of the order, my lord, cutting permission. to cut the trees and transport it to. This is not only one order, my lord. There are several orders has been passed by the deputy conservator of forest. Whereas the land revenue officials and the forest officials are in hand in gloves, my lord, with the owners of the land. And moreover, my lord, the main aspect is that, my lord, here is the, as per the full bench judgment of this honorable court, which is at Annexure C, my lord. In Coorg, my lord, Jamma land and Bane land, we are not having any right over the property. We are not the owners of the property. We are only occupants. We can only enjoy the property, my lord. It is specifically stated in the full bench judgment of this honorable court, whereas in the division bench of this honorable court also clearly stated, my lord, we are not having any right over the property, my lord. The same issue has been dealt by this honorable court, full division bench of this honorable court. I may be permitted to read, my lord, the last 168 page number, my lord. Shall I read, my lord, page number 168, pertain to the same issue, my lord. The honorable court has discussed with regard to the Paradina land also. Shall I read, my lord, 167, my lord, page number?
Anything you took any dictation?
My lord, please take page 248, my lord, the reason for passing the order. And these persons have not been made as parties. Page
No, I am
248.
not challenging that particular order. This is a public interest litigation, my lord. By and large, I am saying that the particular word is save Kodagu.
They have asked
There are
for
large
permission.
scale of this illegal activities is going on in the Kodagu district, my lord. And the same has been continued, then another disaster will happen, take place like Wayanad, my lord, at Kerala state. Whereas all publics know that in 2018 there was a landslide in Kodagu district. These are because of this reason, my lord. And you will also be kindly appreciate during this year, summer, that is in the summer, my lord, at the birthplace of Kaveri, there was no water for almost a week. Then subsequent thereafter, there was a rain, then somehow it has, because of these reasons, my lord, without any mercy, they are giving the permission to cut trees. And suppose permission is given for cut 100 trees, my lord, they will cut more than 200, 300 trees, my lord. All illegal activities are going on in Coorg, my lord. So in view of that, I request you also to kindly pass an interim order not to give permission to cut trees, my lord, till the disposal of this matter, my lord. My lord, I may be permitted to read the page number 167, para 10, my lord, at division bench of this honorable court judgment. Shall I read, my lord? With the above background, let us now examine whether the petitioners are entitled to relief sought for by them in these writ petitions. The claim of the petitioners that they are owners of fully assessed lands used for cultivation of coffee has remained just a mere claim, and they have failed to produce any document to support them claim. On the other hand, the respondents have relied upon the general power of attorney given by the petitioner before the notary on 19 November 2002 in favor of one Mr. Riyadh, wherein the tenure of the scheduled land is noted as Jamma Bane. The record of rights and the tenancy certificate RTC issued by the Revenue Department also states that the tenure of the scheduled land is Jamma Bane and not Paradina, alienated. They are given a new word, my lord. There is no such word called Paradina either in the Land Revenue Act or any notification from the government of Karnataka land. The respondents have taken definite stand that as on 1/4/1964, when the Coorg Revenue Act 1960 Revenue Regulations 1899 was repealed by the Karnataka Land Revenue Act 1964, the tenure of the scheduled lands continued to be unalienated Jamma Bane. This stand of the respondents is well supported by the RTC extracts produced along with the statement of objections filed by the state. Thus, the Karnataka land, therefore, difficult to accept the contention of the learned counsel for the petitioners appellants that the scheduled lands are Paradina lands, and the conclusion gets forfeited by the decision of the full bench of this court in Chakkara Karyappa Puvaya versus State of Karnataka, wherein it is held such privileges enjoyed by the Jamma Bande holder do not entitle him to any subsoil rights in the Jamma Bande land, nor had he any interest of right in the standing trees, and he could not utilize these trees for commercial purpose without payment of full timber value to the government. He was also not owner of the air column above the surface of the land. Whereas the government advocate has supported this aspect, my lord. Based on the government advocate submission, this order has been passed, my lord. And you also I request your lordship to whatever the permission given in which in the column it is stated that, my lord, is a Paradina land. They wrongly mentioned it as a Paradina land, my lord. I request your lordship to kindly turn to page number 224 to 228, my lord. 224, my lord, in the column provision as RTC. 224, my lord. 224 to 228, it is in the column provision as RTC Paradina, Paradina, Paradina. Every till one serial number 1 to 21, my lord. Whereas 22 and 23 stated as Sagu Bane. Sagu.
Repetition with the page. No, no. Yeah, DD is also not there. DD is also not.
And even if the land occupant of the land wants to cut the trees, my lord, in the coffee estate to remove the shade and even then they have to pay the full value of the tree value to the government, seigniorage. Without paying that, they cannot do that, my lord. And it will go to great loss to the government, exchequer to the government, my lord. So in view of this, I request this honorable court to kindly stay the cutting permission, and wherever there are cutting permission has been granted, my lord, kindly stay the same by not to remove the trees, my lord. Timber.
Lord learned advocate Mr. So-and-so by filing paragraph the present petition under Article 226 of the Constitution, as public interest petition, the petitioner is paid for issuance of direction against all the respondents not to issue the permission to cut trees in the forest land, government lands, Western Ghats, and granted holders to Bane land, MBBN, Jamma, JAMMA, Jagir and Hubli lands, UMBLI, in the Kodugu/Kurg district. The prayer is made to not to prayer is made to remove the word into Paradin land in place of Jamma, Bane, another tenures. On the plea that in the Land Revenue Act 1964, any word like Paradin in word form is not found. The essential grievance is that in the Kodagu district, the timber trees which are valuable and the timber obtained thereof has got high cost in the market are being indiscriminately cut and removed for commercial purpose. The allegation that the timber mafias are on work in collusion to remove the trees, to cut the trees of to cut the timber tree. To the serious detriment of the area and in area in particular and environment in general. Notice returnable on 30th September.
No, September.
There shall also be a notice as to interim relief, returnable on the same date. Full stop. It will be open for the petitioner to place on record in the meantime. Place on record if in the meantime, that is from today till the returnable date, any timber tree is cut, found to have been cut, such details shall be placed on affidavit. If you are able to say on affidavit that in this area, this much land trees are cut, then I will consider for interim relief.
Permission has been given, my lord, already. So they may cut and remove the.
So you follow this order if you want further.
Let
us see what happens.
My lord, may I request for a
Copy of the order shall be given immediately to learned additional government advocate, Ms. Nilofer Akbar, to enable her to take instructions on the returnable date. And service by hand summons is permitted to the counsel for the petition.
Much of it.
Urgent. Number 22, writ appeal matter.
Lord, serial number 22, I appeal for the appellant, my lord. The present appeal has been rendered infructuous. The notification under challenge was the calendar of events of an election to the first board of the cooperative society, my lord. The election has taken place and the present writ appeal may be dismissed as.
Appearing online stated that the elections have already taken place and therefore the subject matter and substratum of the present writ appeal has become infructuous. In view of the statement, the appeal will not survive. It is disposed of as infructuous. Learned additional government advocate Ms. Nilofer Akbar has no objection in disposing of the petition on the above ground. No objection.
My lord, I had the information, my lord. I got the information that the election had already, yes.
He confirms that the elections are held.
Yes, my lord. The election has already been held and the board is functioning.
And the board is elections already held and the board has become.
My lord,
functional.
whether the board is functioning may be subject matter of some other.
We'll make it functional.
Thank you, my lord.
23, 24 are urgent. Number 25. Mr. Som Sundar Rao. 25. Mr. Som Sundar Rao.
25 is nobody is there. Delay is there. If nobody is there, then 22nd of October. None present for the appellant. Stand over to 22nd September.
My lord, the name of Renuka may be shown for the first respondent, my lord.
Name of learner is Renuka will be indicated while notifying the appeal on the next day. It is appearing. It's Appearing on behalf of respondent number 1.
This is number 26. Kirti Krishna Reddy.
A short passover may be granted, ma'am. Seniors on his legs.
Malone. In
But
this
there's some
case,
urgency in the matter, that's the.
my lord, one submission, my lord. In this case, the petitioner has filed an application for directions, my lord, to stop the materials, my lord. The copy is not served to me, my lord. I'm the
the
first responding, my lord.
Any urgency?
Please, my lords,
I
we
don't
had,
have any urgency.
we were the impleading applicants before the writ, single judge, my lords. We have, a purchase order before, once the writ appeal was filed before this honorable court, pending the writ appeal, they have, supplied, a purchase order was issued, my lords. Subsequently, they have supplied certain amount of the order. My lords, if the, continue the supply, our writ appeal will be rendered infructuous, my lords. In fact, your lordships on the last date of hearing had heard the learned senior counsel had orally observed for the parties to maintain equities, my lords.
27,
My lords may have it on 26th, my lords.
26.
Please, great.
Notes, could I request one thing, notes? The issue is only this much. The appellant is the L2 in a tender process. Notes, the tender was, I was the L1. Tender was recalled in certain grounds, whatsoever it was. Notes, thereafter, notes, I approached the writ court saying that the recalling of the tender was bad. Notes, they did not file a writ petition. They tried to implead in the same writ petition. Then, notes, kindly see. Notes, the writ court said, reconsider, please reconsider your order of recalling the tender itself. Notes, once the order was reconsidered, notes, now I am L1, notes, and the tender has been awarded in my favor. I am doing the supply. Now, notes, the issue, notes, says they have not filed a writ aggrieved against the challenge at all. Notes, secondly, notes, so far, till date, notes. So far, till date, notes, now we've been supplying the materials. The problem, notes, is this is with respect to the fragrance materials which is added into the Mysore sandal soaps. Notice, if I supply a different batch now, tender is, notes, if my supply is stalled, they'll have to call for something else. But the entire batch of soaps will be affected, which is why, notes, we have supplied more than 40%.
My lords, in fact.
This juncture, notes.
Right.
Please,
By
apologies.
interrupting the council will.
Apologies, ma'am.
This juncture, not this application is filed seeking stall. My only request, not need a even after vacation, ultimately.
You argue, don't argue on 26th.
Let's till 20.
Don't argue on 26th now.
Very the senior advocate, very good. I'll be grateful for whatever.
Wasting time unnecessarily. We have given 26th. Why your wait is wasting time making long submissions?
Very well. Your lordship's good.
Yes, 26th.
Obliged, ma'am.
For 27, Mr. Abhijit Taranali.
But I'm seeking for a start Passover.
No passover. 22nd of October.
Obliged.
At the request of learned advocate of the appellant. Next.
Number 28.
This case, my lord, I am appearing for
Appearing.
respondent. Today they have served copy on me. I have received copy today that there is a 528 days delay and I'll file objection to the IAs.
File it.
Please.
Learned
Another
advocate,
connected
Mr.
matter.
So-and-so,
There is
so-and-so
another matter, my lord. Serial
wants to
number 8.
file reply to the delay condonation application. The same may be filed before the next date, stand over to 24th October.
There is another matter is there, my lord. Serial number 87, arising out of the same matter.
87 to be listed with writ appeal number 1174 of 20.
Writ appeal 1200 of 2020.
Yes.
Please.
It should be tagged on to with this.
Already tagged. You
Please.
give, supply the tag.
Obliged.
Number 29. Mr. DP Mahesh.
For respondent, my lords, kindly attend tomorrow, my lords. Senior is not there.
Tomorrow we are issuing notice.
The lordship may kindly direct notice because there is a delay of 16
Of
days.
16 days. Notice written on 21st October.
Please.
This is number 30.
Let's 30 I appear.
Vish MK.
Notice.
Let's notice is already, my lords, issued.
Already.
My learned friend is already on record.
No, my lord, notice was not issued. He served me a copy. I'll accept notice.
Let's
in the connected matter, which is at 85, my lord, notice was ordered and he is served. The issue remains the same. There is one urgency. Would your lordships please permit me to mention that? My lords, matter relates to selection, my lords, to in the Karnataka Power Corporation. I'm so sorry.
A to prosecute has to be first allowed. He was not a party to the writ petition.
May I just, my lords, 85 is also before your lordships. My lords, the issue would go like this. I will not trouble your lordships with the papers.
This
Let's-
will take time.
May just, what has now happened is this, my lords. They have issued the provisional select list. Now, my lords, 10 days time was given to finalize it, my lords, which would come to an end, my lords, by the end of this week. My lords, your lordship's experience, my lords, certainly would assist your lordships when I say this, my lords. My lords, if final select list is published, some semblance of right is created in third parties, adversarial rights are created. My lords, second submission, my lords, second submission, no, it's not refused and my learned friend is here. My lords, my second submission would be this. My lords, as a counsel, my lords, who has done some matters on service side, my lords, I would say, my lords, that even those persons who are selected,
We'll consider day after.
very well.
Serial number 85, which is the connected matter. But the notice to respondent number 4 may be dispensed with. That is the only office objection. Not an order is required. But in serial number 85 may notice to R4 be dispensed with. That's the only office objection.
Lord, serial number
The
80,
connected.
88 is also same, my lord, challenging the same order, my lord, 88
All
also.
together on day after tomorrow,
Please.
we'll consider
Please.
whether it is urgent or not.
I'm so grateful.
My lords is having this day after tomorrow, my lords. Is your, could I request for the day after that Thursday, my lords? Wednesday, I'm required to go to the Dharwad bench. Subject to your lordship's convenience. Could it be on Thursday, my lords?
27th,
27th, my lords? Yes, my lords. 27th, if your lordships could.
27th.
Grateful,
Seek
my lords.
one more in, may I seek for 2:30 if it's not income.
We'll see on that day out.
Permit me to mention at that.
Now in this week, all matters are at 2.
I completely bowed on to that, my lord. In fact, your lordships have fixed another matter of mine at 2:30 on 27th. But there, my lords, that is recovery of money. Here, the lives and livelihood
Now
of
we
people are.
publicly announced today that all matters.
My lords, out of 19,000 people, 9 people are before my lords asking to cancel the exam.
We have not sought for cancellation
We
at
are
all.
not seeking for
Not for
cancellation.
cancellation. 85 is for cancellation.
We'll see on that.
May I make a mention on that day at 1:30, my lords?
1:30, no.
2:30. So grateful. I'll come back to your lordships. Grateful for your lordship's intelligence.
Thirty-one dispose, number 32. Abhishek Mali Patil.
My lords, may I kindly fix a date for hearing, my lords. It has to be taken up for hearing. None of the IAs survive.
Please,
except for hearing.
5th of September, 5th of November.
Much.
Number 33. TP Muttana.
File an application for substitute service, my lord. Summons is not served. File an application order, rule 520, my lord.
Delay is also there. Delay of 7 days. 33. Where is your application for substituted service? Not listed. It is not. Where is your CA paper publication? Only delay is listed. Mr. Counsel is not listed. Your application for publication is not listed.
Oh, yes, sir.
Achha, yes, it is listed. So you want service by newspaper or by posting? Affixing. Service by affixing or by newspaper? Times of India. All right, we are granting it. It will be published in the newspaper and the returnable date will be on 13th November. 2 of 24 is grant.
34.
I appear for the appellant in this matter. So I appear for the appellant in this matter. It's after hearing for some time on the last occasion, minutes,
Correct.
interim order was granted and whether the
So
council
to
was.
find out whether the petition can be accommodated.
Yes, accommodated minutes,
Lords, even, my lords had directed that to produce whether they were accommodated in other departments. That is ready, my lords. My lords may have it tomorrow, my lords, senior counsel.
Tomorrow, no. 23rd of October. Please send out to 23rd.
Please, minutes 34 and 35 minutes are interconnected.
Both are identical, yeah.
Please, minutes, I had the interim order minutes benefit till today. That has to be
What is the
extended.
interim order?
Minutes, stay of
Stay of
the
judgment.
order passed by the learned single church.
Interim order
was granted on
23rd of October. Interim order granted earlier to continue, shall continue till the next.
obliged.
Both, in both order is operative. Common order will do.
Common
So
order.
it arising out of same judgment.
It's a common order.
Common order in 34 and 35. Both the matters to be listed on.
Obliged.
This is number 35, 36.
Validity of rules are under challenge, my lord. There was an order of status quo granted. And I have filed an IA seeking early hearing because my promotions are all held up because of the status quo order. Let the promotions be granted subject to pending appeals, my lord. The rules, 2011 rules, my lord, provision relating to grant of promotion from the cadre of junior engineer to assistant executive engineer. Government has also filed an appeal, my lord.
There is a delay of 169.
My lord, that is in respect of the government appeal, my lord. My appeal is 863 of 2015 was filed in time. And after hearing, my lord, status quo order was passed.
So you're appearing on, in the 36, so you're appearing?
Yes, my lord. That is connected with the 36.3,
169
my lord.
36.
My lords, I appear for the connected matter in this, my
How long
lords.
the delay?
Please, Milords.
Delay is gone down.
Please, Milords. Delay.
136 days, 116 delay is gone down.
Please, Milords.
This application,
Also.
this is IA.
863, my lord.
IA number 1 of 224 in writ appeal number 200 of 24.
That's 36.5.
This IA is filed, trying to condone the delay of 169 days, which has occurred in filing the writ appeal by the state government. Whereof the accompanying affidavit spells out the reasons for passage of time. It was stated that because of administrative process and that the files passing through the hierarchy of authorities to culminate into the decision to file the appeal, the time was consumed, full stop. Since the applicant is state government, in the decision-making process at its end, consumption of time is inevitable to some extent. Full stop. Viewed from this angle, the delay of 169 days could be said to have been explained with sufficient cause. It deserves to be condoned. The delay is condoned, application.
36.5 minutes.
Same order in 36.5.
5. Please, Milords. 2 state appeals.
36.4 is by whom? Or that is
Private party.
IA, now 36.4 IA number 3423. Delay of 3 days is condoned after hearing both the.
My lords, 36.5, I am for the appellant in this matter, my lords.
Pardon? So delay of 3 days is condoned, IA 2 of 23 is allowed, 36.4. Then 36.1 delay, 36.1, IA 1 of 1 for 24. The prayer for early hearing is allowed by directing all the writ appeal connected with the present appeal as well as the present writ appeal to be posted on 6th of November.
Seeking for an indulgence with regard to modification of the interim order, my lord, for the reason that, Lord, the promotions from
Lord, your lordship, the validity of rule of 2011 are under challenge, my lord. And your lordship may kindly see the order passed by this honorable court, my lord.
In
on-
promotion, never there is an urgency.
My lord,
Promotion can always wait. Next. Please.
My lords, the date may be fixed, my lords.
6 November, sir. Bill number 37 is urgent. Number 38. Master RKGMM Mas Swamiji, party in person.
My lords, I have filed IA 2 for early date, my lord. I have filed IA number 2 for early date, my lord. It was urgent for long date on 25th October, my lord. It is a stage for order on
You filed
office objections and submissions, my lord. Matter is very urgent, my lord. My supertemnical promotion has been deferred, my lord.
Where is that? Early hearing application, 2 of 20.
2 of 24.
It is for early hearing. 2 of 20, heard, learned part in person, the prayer for early hearing is granted. The appeal shall be, the petition shall be, the appeal shall be listed
My lord, Honorable Supreme Court
Hearing.
has
on 26th November.
has already given substantial relief, my lord. Honorable Supreme Court of India has already given substantial relief to me, my lord. It is specifically ordered for approach the Honorable High Court for reconsideration of relief of supertemnical promotion, my lord, but it is not complied, my lord. No, when I gave sixth representation for reconsideration of supertemnical promotion, my lord, it is deferred as the matter is pending on judicial side, my lord. It is deferred, my lord. Please, my lord. I am serving as senior most district judge since from 16 years, my lord. For supertemnical promotion eligibility and entitlement is 8 years, my lord.
Your application for early hearing is allowed. The matter is fixed on 26th of November.
My lord, office objections are
Not removed.
my lord,
Not removed. Then the right.
office objections are there.
The matter shall be listed only after the office officers are removed.
My lord,
Only after office officers you remove, we'll list it. Yeah, the
it is urgent on
application for early
25th
hearing-
October, my lord.
Now listen.
Please,
The-
my lord.
Please listen.
Please, my lord.
The application for early hearing as well as the main writ appeal shall be listed only after the office objects are removed by party in person. Now, next.
25th, my lord.
39. Mr. Sagar BB.
Lords, it is passed. Today, my lords, it is served on me. Of the day's accommodation, my lords, I'll just go through this.
27th at 2:30. It is complied with.
Will not reason for complaints. Their already endorsement is issued. He is not entitled for the salary, only for the lordship can, because that is the part of the contempt petition itself, they have placed annexure C.
So representation is considered.
As per the single judge
So
order.
that is what we are asking.
Yes, it has been considered and rejected.
Reserving liberty to challenge that.
That's it. Learned advocate, Mr. So and so for the respondent, file statement of objections from compliance affidavit to state on the basis of the statement made in the affidavit that the necessary endorsement is issued, deciding the representation of the petitioner. Full stop. It is to be recalled that the directions of learned single judge was to direct the respondent to recite the representation. Therefore, in view of the endorsement, the direction is complied with. Full stop. The representation is rejected. Full stop. Nothing survives nothing survives in the present contempt petition. Paragraph. At this stage, learned advocate Mr. So and so for the complainant stated that the liberty may be reserved for the complainant to challenge the endorsement on merits. Full stop. Such liberty is reserved. It will be open for the complainant to institute independent proceedings to challenge the endorsement on merits, in respect of which, however, this court does not express any opinion.
Published.
Number 40. So G.A. Shekantagowda.
Lords, we have filed writ appeal, my lords, in this matter.
How many minutes? Complied with.
They have issued the allotment letter.
Learned advocate for the respondent stated that the endorsement is issued.
My
My
lords,
lord, allotment letter, please issue.
I'm sorry, my lords, not in serial number 38. It's not.
Pardon?
Not in serial number 38 minutes. Next matter.
Learned advocate for respondent files memo dated 23/9/24, whereby copy of the allotment letter dated 13/9/24 issued by the Deputy Secretary, Bangalore Development Authority is produced. Full stop. It was stated that this marks compliance of the directions of learned single judge brought under the contempt jurisdiction. Paragraph, learned advocate for the petitioner, Mr. So-and-so, would not dispute the factum of compliance. Paragraph, in view of above, contempt proceedings did not survive and they are and disposed of accordingly. Yes, next.
Number 41, the Chetan Kumar.
My lord, I appear for the complainants, my lord. My lord, here,
Will we reply? Learned advocate, respondent wants to file reply, stand order 24th of October.
Number 42.
We have filed a writ appeal in this matter.
The last occasion, Lordship had directed not them to make the revenue interest name of the petitioner. Once the submission was made, that writ appeal is being filed. So,
Lordship had granted 2 days' time, my lords, to file the writ appeal. We have filed the writ appeal, my lords.
Appeal is filed. It was
Appeal.
stated by learned additional government advocates, Ms. Neil Pramodini Kishan, that the writ appeal is filed against the order, judgment and order, against the judgment and order brought under contempt. In that view, these contempt proceedings may be listed along the writ appeal on
That's, my lords, 15 days' time may be granted.
25th of October,
not one submission, not.
25th October.
Lords, a lot of translations are there bulky, my lords, 15 days' time may be granted.
On that day, you can ask time for removal of your office object.
Not meanwhile, not.
Obliged, my lords, obliged.
You want 15?
Obliged.
Not.
Best part of our, best part of
Yes.
advocacy is not to speak anything.
Please.
So we'll grant you the 2 weeks' time.
No, my lords, your lordship may
2 weeks.
grant the earlier date granted,
Earlier, we'll give it to be listed on 16th of October.
please.
Meanwhile, not one submission. It's only a matter regarding Lord's change of revenue entry. Her name is already there in the revenue records. It has to computerize. Meanwhile, till the pendency not if they.
Did you argue and the appeal is
Much.
listed?
Number 43 adjourned. Number 44, Mr. Krishnamurthy N. 44.
Appearing for complaint, my lord. Complaint,
Complied with.
complaint.
BBMP.
What do you want?
BBMP.
So what do you want?
My lord, 44 to 48 are batch matters.
22nd October.
That's 44 to 48. I represent BBMP. I take to file my part today morning, my lord, I have received.
24.
Please.
My lord, damages are already 250 crores in this matter, my lord. They went till Supreme Court and they have failed. So again, they came back and relinquishment deed is of 2015 and till now they have not issued the TDR certificate also. Wherein the writ petition also, court has ordered to impose damages of 1,000 rupees per week.
Let him file Vagaratnam. Take instructions.
Number 49.
I appear for the
Devi
state.
Prasad Shetty.
Serial number?
40.
In this contempt, your lordship, the time that is granted in the writ petition ends only in the month. It's a premature contempt petition, your lordship. There are elections to the cooperative societies to be held. The time granted by the learned single judge is till the month of October. I will read it, your lordship.
If they want to say anything like and for an objection, because election process means it not starts only one day, ends on that day. It has to be complete. There are several stages are there. They have to commence. Now 14 rule 14 notification was issued by the election authority. Then calendar of events have to be notified by the returning officer. Dates have to be given for filing nominations, scrutiny, withdrawal and other things. Nothing has been done so far, man.
Where is the direction, but?
That's 3/7/2024.
Page
July.
29 of.
Election could have been completed on
Page
2nd
Page
October.
29, your lordship. Page 29,
This is
paragraph C. Of the
3rd
order.
July
The
2020.
district election officer shall ensure that the process of election shall be continued from the stage when it was halted,
Correct.
and ensure that the elections are held as expeditiously as possible and at any rate within a period of 3 months from the date of the receipt of the copy of this order. Now, your lordship, the order is passed in the month of August,
No, July.
July.
Copy is delivered, complaint representation was made. Election process may not now pursuant to this order. Election authority have issued a notification under Rule 14. The calendar of events has to be notified by the returning officer. Some process may not, they could have been commenced by this time.
What was the stage which was left out?
Nothing except the 14-1 notification, there is no further progress in the matter. Even in the
There must be a-
notification, my lord,
There must be a statutory time period.
Yes, your.
Yes.
30 days.
according to the annexure B, page 35,
The date of notification till the completion.
my lord, may I request your lordship to page 35, page 35 may kindly be seen. According to the election officer, the election should have been completed on 28/9/2024,
What
page
does-
35.
What does this mean? The elections are held expeditiously as possible and at any rate within a period of 3 months from the date of receipt of this order.
This order, copy of this order.
So three months will expire on 3rd of October.
Yes, sir.
3rd August. Nothing is except issuing 14 rule notification. No other things have taken place.
On the next date, from a learned assistant government pleader is directed to specifically state by filing an affidavit as to the steps taken by the competent authority in terms of directions of learned single judge, which requires the holding of election to the cooperative society within 3 months from 3rd July 2024. Full stop. The grievance and the clear grievance of the case of the petitioner is that no steps at all are taken, much less holding of elections, towards the election. Full stop.
We will submit.
Unless the satisfactory reply is filed, a serious view will be taken. Put up on 30th September,
30th September.
Monday.
Very well, grateful, grateful.
My lord, in submission, my lord. Its objections are complied, my lord.
Complied.
Complied, my lord.
So
Please, my lord.
then we have kept it on your application.
Office objections are complied, my lord.
Complied.
Complied, my lord.
And the application number, which is the application?
Complied, my lord.
But there is some is left out. You comply with?
Please, my lord. Complied, my lord. Complied, my lord.
Not complied.
Complied, my lord.
You go to the office and see what are the objections.
My lord, please, my lord. Please, my lord.
Then we'll take up
It
your
is-
matter
it is
immediately.
compliant, my lord. Please, my lord. First office objection is jurisdiction
Yeah, we are-
stated at writ of a- It is compliant, my lord.
We are not registrars.
My lord.
We are not registrars.
Complaint, my lord. Complaint, my
We are
lord.
not concerned. Go to the registrar and satisfy them. Don't say that this office has been complied with before us. You are not supposed to tell all these things to the court of law. You go to the registrar, registry and satisfy them.
Yes. My lord, only,
We are not listening to your office.
please, my lord.
Mr. Party in person.
Please, my lord, please.
List number
Or we are registrars.
My lord. Please, my lord.
So go to the registry and
Register,
satisfy
my
the
lord.
registry.
Register, my lord. Please, my lord. Please, my lord.
Yes, next.
List number 3, the pronouncement of judgment. Seal number 1, Mr. Abhishek Mali Patil. In the
You are-
petition WP.
Mr. Ramesh, you are also there in? Yes. On behalf of? And who is for the institution?
Well, it's institution and the student are petitioners.
Both.
In this writ petition, one writ petition.
This is 1565.
1565.
So for the reasons recorded above, no, not to be, this is pronounced, for the reasons recorded above, in view of the analysis of facts made and the total discussion supplied, the court concludes that the conduct of the petitioner number 1 institute in dealing with the admissions in question was highly irregular. The petitioner number 1 institute acted far from bona fide, to say the least. The conduct smacked commercial mindedness and to derive unjust enrichment. If such conduct is countenanced and not treated with stern approach by the court, it will open the doors for irregularities, giving the colleges and institutions a license to commit further irregularity in any other admission process of such kind and nature. In that view, the petition number 1, Srinivas Institute of Medical Science and Research Center, is imposed with cost of ₹5 lakhs. The amount of cost shall be deposited with the Karnataka State Legal Services Authority within a period of 4 weeks from today, and the receipt thereof shall be produced on record for the present petition. At the same time, petition number 2, student who was admitted to the MBBS course for the academic year 2022-23, has undergone the studies in the course since having been admitted. It is an admitted fact that petition number 2 has completed substantial period in undergoing studies, and she is in the middle of the course. The court is not inclined to upset the admission of petition number 2, notwithstanding the above, so as not to disturb her educational career. Furthermore, the student in whose seat the petition number 2 was given admission has not come forward to claim the admission on that seat, nor any fact is established which may go to suggest that petition number 2 has either colluded or has played a role in seeking admission to the course by committing an irregularity on her part. In the circumstances, petition number 2 shall be permitted to continue her studies to the end, and for that purpose, her admission stands approved. The petition is allowed to the aforesaid extent, and the cost of ₹5 lakhs will be paid by the petitioner 1 as above.
My lords, I think your lordships, my lords, I heard your lordship saying. PG, yes, my lords.
PG.
Post, your
not
lordship
MBBS.
said MBBS, my lords, PG. In the directions, my lords, that may have to be
We'll correct
kindly
it.
changed.
We'll correct it.
We agree.
Any submission?
That's to
Then
that.
we'll record it. You want to record it?
My lords, in identical matters, my lords, there was a direction apart from fine to give a seat to the government for the next year.
Not a single seat?
Which is stayed by your lordships, my lords.
My lords, the cost to be deposited here, my lords, wherein, my lords, because only, this is a PG seat, my lords, 5 lakhs is nothing, my lords, for them. So 1 seat for, under government quota. So government stood.
The government quota, that was the update. So that it is a penalty, my lord.
Since my lords have
Anyway, yes.
My lord, one submission, my lord. I have to take the far number C, my lord. It is the office objection, my lord. Whether I have to take this far number C, my lord. Under Rule 10, my lord, it is the discretion of the honorable court to permit the party in person, my lord. It is already permitted. I was
We'll hear you when your matter is notified.
I will. With the lordship's kind leave, serial number 75, first leaks may kindly be listed on October 1st file.
Why?
Public interest litigation, it is the people largest is involved. The respondent is creating third-party interest in the lands.
Not first. What is the law? It will go after holidays.
After my lord?
The lordships
After
kindly-
May I,
lordship. And seat number 85, the lordships have posted it on 27. The only office objection is regarding not the furnishing of PF. I have filed a memo not seeking to dispense with notice to respondent number 4. An order may be passed to that, to dispense with notice. I have already served the counsel to the respondent. Only to that limited extent.
What do you want? Office objection regarding?
I filed a memo not seeking to dispense with notice to respondent number 4. The office objection is with regard to furnishing of PF to notice to respondent number 4. That may be dispensed.
Office, which serial number 85.
85.
The office objection regarding issuance of notice to this number 4.
4.
Is dispensed with good time being. Full. So pending such consideration, the appeal may be listed for.
Lordship, serial number 83.
The week beginning from 21st October.
Lordship, serial number 83.
Who is this 80?
Office objection has been compliant, my lord. Given a short date possible, my lord, because it was last heard in the month of April, my lord.
Court master will give the date.
Obliged.
My lord, serial number 67.
Whole date to be given after.
For the accused, my lord, 667.
24th October.
Matter, there is a urgency because the filing of this contempt is being utilized in the lower court for modification of the order on which I am for contempt.
My lord, I'm for
There is
accused. My lord, I'm for
one
the.
office objection with respect to the affidavit which I will comply. A date may be
My lord,
fixed
any
in
day
the
after
matter.
28th, my lord. Because the matter is listed on 28th in the lower.
23rd October.
Very well.
My lord, I'm sorry, the date.
71 and 73, my lord. 23rd or
24th October.
please.
My lord, serial number 79, my lord. This is a matter pertaining to CBSE, my lord. The school is not registered under CBSE and continues to be advertising as CBSE, my lord. We have considered their applications on multiple occasions, my lord.
PIL.
My lord,
It is PIL.
my lord, it's a matter by the CBSE, my
For
lord. It's
student.
appeal. No, my lord, by the board itself, my lord. Kindly set a date in the matter, my lord.
After holidays.
My lord, October 24th,
25th.
obliged, my lord.